Faites l'appel, s'il vous plaît, Madame le greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent.
Présente.
Monsieur le connétable de Saint-Brelard.
Présent.
Monsieur le connétable de la Trinité. Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Martin.
Présente.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Grouville.
Présent.
Monsieur le connétable de Saint-Ouen. Monsieur le connétable de Saint-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le député Southern. Madame le député Labbé.
Présente.
Monsieur le député Tadier. Monsieur le député Luce. Madame le député Dublé. Monsieur le député Morel.
Présent.
Madame le député Lehegara.
Présente.
Monsieur le député Ayer. Monsieur le député Ward.
Présent.
Madame le député Ells.
Présente.
Madame le député Gardner. Monsieur le député Ghost.
Présent.
Monsieur le député Farnham.
Présent.
Madame le député Moore.
Présente.
Monsieur le député Mezek. Monsieur le député Joseph. Monsieur le député Balash.
Présent.
Monsieur le député Coles. Madame le député Poré. Monsieur le député Wall.
Présent.
Madame le député Miles.
Présente.
Madame le député Scott.
Présente.
Monsieur le député Renner.
Présent.
Madame le député Curtis. Madame le député Feltham.
Présente.
Madame le député Binet.
Présente.
Madame le député Jeune.
Présente.
Madame le député Miller.
Présente.
Madame le député Howell.
Présente.
Monsieur le député Binet. Monsieur le député Ferry.
Présent.
Madame le député Kovac.
Présente.
Monsieur le député Curtis.
Présent.
Madame le député Ward.
Présente.
Madame le député Wilson.
Présente.
Madame le député Stevenson. Monsieur le député Andrews.
Monsieur le doyen.
Notre soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi les gouvernements et les puissances de la terre, pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien et au soulagement du peuple qu'il t'a plu de commettre à leurs soins. Car nous t'en prions, au nom et par les mérites de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné à t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite sur la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi est la règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le connétable de Saint-Hélier. Madame le député Dublé. Monsieur le député Mezek. Monsieur le député Joseph. Vous jurez que Monsieur le député Joseph est tellement indisposé qu'il ne peut pas assister aux États sans exposer sa santé.
Malade.
Madame le député Poré. Madame le député Stevenson.
Présente. Ma'am, oh, you're there.
Et les États sont constitués. On behalf of members, I'd like to welcome His Excellency to the Chamber this morning. Before we commence public business, a decision needs to be made about whether to reduce the lodging period in respect of a matter on the order paper. Minister for the Environment, do you wish to make the proposition under Standing Order 26.7 that the lodging period be reduced to allow the draft sea fisheries, trawling, netting and dredging amendment regulations be debated at this sitting?
I do, please, sir. P18, as you've just said, is about trawling, netting, dredging. I missed the deadline by literally a couple of days, and as indicated at the last sitting, I would hope members would allow me to bring it further in the sitting.
Thank you, Minister. Is the proposition seconded? Yes, sir. Does anyone wish to speak on the proposition? A member content to adopt the proposition? The proposition is adopted and the lodging period reduced. The first item on the order paper is the suspension of Deputy Joseph of St Saviour, lodged by the Privileges and Procedures Committee. I ask the greffier to read the proposition. Deputy Banish.
Sir, may I be permitted to make a proposition before we proceed to this debate? I should like to propose that Projet 47 be postponed until the 24th of March. Deputy Joseph is malade. He was signed off by his doctor on the 6th of February, and that sick note has been extended until the 20th of March. It is a fundamental principle of natural justice that audi alteram partem in the Latin, in English, hear the other side. The deputy wishes to be heard in his defence. He is unable to be here today because he is malade. It seems to me that it would be unconscionable for the Assembly to proceed in his absence to hear this debate, and I therefore formally propose that the debate on Projet 47 be postponed until the 24th of March.
Is the proposition seconded?
Yes, sir.
Does anyone wish to speak on the proposition? Deputy Elliott.
So it's a question really for the mover of this proposition. If the Latin principle that he quoted is fundamental, that the person who's in receipt of a sanction should be present to hear it and defend themselves, what happens if that person is also malade on the 24th of March? There's no indication to us that Deputy Joseph is going to necessarily miraculously get better by the time of the next sitting, and indeed I don't know why he would. And do we keep putting it off ad infinitum, to use another bit of Latin? Or do we actually acknowledge that a very serious offence has taken place, much more serious than the offence for which he was suspended for 28 days in the first place, which was, let's face it, a speeding infraction, which is not insignificant, but it didn't have the threat of a jail sentence with it. And I think that if we do pass this today, we're simply kicking the can down the road. This does need to be dealt with. And in the same way that a defendant in court could not perpetually put off their day of reckoning by simply not turning up because they're sick, I think we need to also apply those same arguments to ourselves. I think we do have to be aware of the public optics in this. We know that only this week, following on from an inquest of a migrant worker in Jersey who lost his life, in part due to, shall we say, unfit living conditions, I'm sure it's very complex, that there are real vulnerable victims in Jersey, and that this wasn't a victimless offence. And unfortunately, within this assembly, there seems to be an attempt to portray And we do have to be mindful of course, of our own colleagues' well-being, but we've lost sight in that, I think, and the public are very aware that this was not a victimless offence, and that the two victims that we should really be thinking about are the ones who were exploited by a member of this assembly. And I don't think by putting this off for an extra 2 weeks, A, is the right thing to do, and that should be sufficient for us not to support this proposition. And secondly, it's not what the public would expect of an assembly which has a code of conduct to hold itself to the highest standards, sir.
Thank you, Deputy. Deputy Renouf.
Yes, sir. I rise to support what Deputy Tadier has said. As he says, there is no guarantee that Deputy Joseph will return in the next sitting. He cannot know that. It's not just the question of what he's ill with now. He could be ill with something else. So we have to face the decision now. I think the issues at stake are well known. The criminal case has been heard. The verdict has been reached. The issue is whether there has been a breach of the code of conduct and whether that breach is sufficient to justify the sanction. Those are issues which we are capable of determining, in my view, with or without the presence of the member concerned. I think there is a danger here that we are engaged in a debate here that is effectively beginning to normalise a behaviour that has been unconscionable. And I think it is the case that we should not be in this position. I cannot think of another member of this assembly in this position who would not have resigned in this circumstance. And we should be acting in a way that makes it absolutely clear that what has gone on is completely beyond the realms of what is acceptable for a member of this assembly. It is not an issue that demands a huge amount of consideration in that respect. And I would also say, although I'm very reluctant to talk matters of justice with one of the most distinguished legal figures in the island's history, really, but the public will see this very, very clearly as a question of justice should be done and should be seen to be done. And the question that we face here for the public is a really simple one. It looks as if the effect of the proposition from Deputy Balash has the whiff of the establishment looking after itself. And I think that it is hard to imagine, for example, whether the same generosity might have been extended to somebody who was a mortal political foe of the deputy. And I do think that the question before us here is a simple one. It does not require a huge amount of discussion. If Deputy Balash's proposition is defeated, I hope that the chair of PPC will stand and make a very short speech to putting the case, and we can vote and get on with our business, because I think that's what we should be doing. But I do not think that the case exists here to delay this, which would effectively potentially time out the Assembly's ability to make a very clear judgment on what it considers to be acceptable and not acceptable behaviour for a States member.
Thank you, Deputy. Conor Thompson-Hellyer.
Thank you, sir. Both of the last two speakers have sought to widen the debate on this proposition to discuss P47 itself. And we can hear from the foot stamping how the majority of States members appear to feel about P47. I want to go back to the first speaker, Deputy Tadier, who referred to well-being of States members. What crocodile tears he was shedding when he said that. I'd like to know how many States members actually have spoken to the Deputy or visited him to familiarise themselves with his state of mind. I have spoken to him and visited him on several occasions. And I'm not a doctor, sir, but he is not well. He is malade. And if he is malade on the 24th, then so be it. Do members have to have their pound of flesh? I would suggest that they should not, and they should rise above it, and they should show some statesmanship, really, because all I can see, sir, is a desire to curry favour with the public. Certainly, so I don't know how many members have visited the member, but I don't believe many have, and I will therefore be supporting Deputy Banish.
Thank you, Conor Tile. Deputy Scott.
Thank you, sir. I just want to talk about conflation and also what the current P47 refers to, which is the driving offences. It doesn't actually mention anything to do with breaches of the election law. The actual proposition says it's an agreement to suspend Deputy Osif as a sanction for breaches of the Code of Conduct. And then it goes on to basically refer to the driving offences, I believe. I don't believe it's saying anything about breaches of the election law. I mean, I'm sorry, am I wrong?
I think you are wrong, Deputy Mayor.
Right, sorry.
Deputy Scott,
Am I reading the wrong thing?
The first paragraph of the report speaks about Deputy being found guilty and sentenced to 120 hours community service, equivalent to 6 months in prison for assisting unlawful immigration.
Right, but we also have heard, so he has been sentenced, but I also believe it was reported that, that a number of individuals were used to distribute information before the last election. I don't know if that's true or not. But one of these things a court looked at and punished, and another we heard that there was no ability for the election Jersey Election Authority to do anything. And that indeed has troubled me, because I have thought, well, that looks like statesman, you know, that the possibility where the deputy, were he not to be, you know, have an actual proposition brought against him in respect of such a thing, he has no sanction. He has had a sanction for the other offence. So I just remain. I just feel that this proposition actually doesn't perhaps address a very important point about justice could be seen to be evaded anyway, or that we're kind of conflating this discussion because it's not actually to do with the Code of Conduct. I'll listen to arguments, sir, but I just remain uncomfortable about the basis of this proposition, and I would be happy, I would welcome the PPC, chair the PPC, to talk a bit more about the extent to which he thinks it's acceptable for the States Assembly to give punishments on top of the court, and the lack of any comeback for what is alleged to be breaches of the election law.
Chair of PPC.
Thank you, sir. I presume that this matter may arise, so I ensured that this topic was debated by PPC yesterday morning. We had a long conversation about whether the P47 should progress, and it was determined unanimously by the members present that it should. This matter was obviously raised also on the 24th of February when we had the discussion about shortening the lodging period. And at that stage, I said in response to a question that I have no intention of preventing it from being debated on the 10th of March, and that is in Hansard. And so, therefore, sir, I maintain that position, and I ask members to reject this proposal. Thank you, sir.
Thank you, Chair. Conor St John.
Thank you, sir. So I'm pleased to follow the chair of PPC, sir, because I believe he did the right thing at the last assembly by not shortening the lodging period and allowing the debate to take place today, sir. Sir, we are not employees, but if we were employees, Deputy Gorse suggested that you couldn't have a hearing in the absence of the employer at the last sitting, sir. I quickly sent him a screenshot from ACAS, sir. You can have a hearing in the absence of somebody, sir. And that's both said by JACS in Jersey and ACAS in the UK, sir. Sir, the deputy has had plenty of time to prepare his defence, and he doesn't have to give his defence, sir. Any member in this House can stand up and make a case for the deputy. Sir, as long as you give due notice to people that a hearing is going to take place, sir, the hearing can happen. And anybody wants to look that up on JAX or ACAS, feel free to do so. Sir, the public elect us to make decisions, however difficult they may be. Sir, I have a drop-in every week, sir, and there's not a week goes past when I'm not asked about my views on the deputy who's pleaded guilty and now been sentenced. I tell them quite clearly, sir, I'm really disappointed. Sir, I would have hoped, like other members, sir, that the deputy would have done the right thing and resigned, having pleaded guilty, not to a motoring offence, sir, but to a serious offence involving other people. And I would have hoped, and I still hope, that the deputy would resign from his position. So there's no need for a by-election, but I think we could have all done without this debate and the following debate, if it happens, if the deputy would have resigned. So well-being is very important. So in my experience, which was quite vast in employing people, sir, hundreds of people, sometimes delaying a decision actually has a negative impact on people's well-being. So you have to take the individual's health into account, sir, and often delaying a decision only adds to the stress and the strain an individual may be facing. And I believe, sir, that we have a duty to make a decision today, whichever way that goes, and that would take some pressure off the individual, I believe. And, sir, I won't be supporting Deputy Baloch's proposal to delay this debate, sir. I hope members will support it. I hope it's a very brief debate, sir. I think we all know what we've read in the newspapers. Most of us will have read the court judgment, sir. It's very clear. We can make a decision, and let's do it swiftly. Thank you, sir.
Thank you, Conor Tarr. Does anyone else wish to speak on this proposition? Accordingly, I call upon Deputy Balash to reply. Deputy Balash.
So I'm not going to respond to the prejudicial remarks that have been made by some members, other than to say that they emphasise, in my view, that it would be right that Deputy Ozov should be here to respond to them. I think this is fundamentally a question of fairness. That's how I leave it to the Assembly. I ask for the up bell.
Thank you, Deputy. The appeal has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. The proposition has been rejected. 11 votes pour, 35 votes contra, and 2 abstentions.
Could we have the 11 and the 2, please?
Yes.
Those voting for the Conotub of St Helier and St Saviour, and deputies Labby, Luce, Gorst, Moore, Balash, Wall, Rose Binet, Tom Binet, and Wilson, and Deputy Howell and the Constable of Trinity abstained.
I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to agree to suspend Deputy Philip Francis Cyril Ozov of St Saviour in accordance with Standing Order 21A with immediate effect for a period of 28 days as a sanction for breaches of the Code of Conduct.
Chair of PPC.
Thank you, sir. The Privileges and Procedures Committee has brought the suspension proposal to sanction Deputy Ozov for breaching the Code of Conduct. The committee has a responsibility to protect the reputation of the Assembly and uphold member standards in relation to the Code of Conduct. Deputy Ozov has been found guilty and sentenced to 120 hours community service for assisting unlawful immigration. Rules 6 and 7 of the recently updated Code of Conduct provide the following. Members must not act or behave in a manner in the course of their public and private life that brings the Assembly or its members generally into disrepute, and should conduct themselves in a manner which strengthens the public trust and confidence in the integrity of the States of Jersey. And Rule 7, members must uphold the law in accordance with their oath of office. The committee considers the Deputy Oath's actions represent a breach of the Code of Conduct, and that the proposed suspension is proportionate in this instance, as the Deputy's actions and lack of regard for the island's laws and judicial process have damaged the integrity and reputation of the Assembly. If adopted, the suspension would, in accordance with Standing Order 164, take immediate effect and would banish the Deputy from the States Chamber and its precincts, restrict him from any parliamentary activity and withhold his remuneration for the duration of the 28-day suspension period. Mindful that Deputy Joseph was marked as mallard at the first meeting, we took the decision not to seek reduction in the lodging period. The committee has a duty of care to members in relation to health and well-being and wants to treat the Deputy fairly. However, it also has a duty under its terms of reference set out in Standing Order 128F to take the necessary steps to enforce the Code of Conduct and promote high standards amongst members. In this case, the committee has concluded that a breach of the code has occurred and is mindful of the strength of feeling from both elected members and the wider public. The committee does not consider it right that this matter is delayed, because it is important we signal to the public, who will be voting for a new Assembly in June, that we consider breaches of the code to be serious and we want to protect the reputation of this Assembly and its members. We must be seen to act when a member breaches our code and demonstrate to the voting public that they can trust us to do the right thing. Trustworthiness relates not only to the behaviour of individual members, but also to our ability to show that behaviour is of a high standard and will be dealt with if it falls short. If we wish to rebuild Islanders' trust in this Assembly, we have to take action when our code is breached. Sir, I make the proposition.
Thank you, Chair. Is the proposition seconded? Yes, sir. Does anyone wish to speak on the proposition? Deputy Banish.
So the chair of PPC has said that the states have a responsibility to protect its reputation. And that is true. But for my part, I think that this proposition damages rather than protects the reputation of the Assembly. Deputy Joseph has certainly done wrong, and he has been punished by the Royal Court for that wrong. The proposition damages the Assembly because it takes no account of the fact that Deputy Joseph has already been punished by the Assembly for these very acts. On the 11th of November 2025, he was suspended for a period which turned out to be 12 weeks, 3 times what is now asked for. I hope that no member will say, oh, well, that was just a neutral act. Neutral it might have been, in the words of the Standing Order, but it was also a humiliating punishment which has had a devastating impact on the Deputy. There is an air of vindictiveness about this proposition which is unworthy of the Assembly. It is almost as if some members cannot abide the fact that he was not sentenced to more than 3 months' imprisonment. In fact, he was given a punishment which, in my view, was fair and appropriate. Unfortunately, the reporting of his case has not all been fair and appropriate. The impression has been given in some quarters that Deputy Ozef was guilty of conduct tantamount to modern-day slavery or to exploitation of vulnerable employees. I have read the judge's sentencing remarks very carefully, and they make absolutely no reference to modern-day slavery or to the exploitation of employees. Indeed, one employee stated that she found working for the deputy enjoyable and fun. They were paid more by Deputy Ozef than by the hotel, and they were grateful for the extra income. That is what the court said. The court heard all the evidence, and I prefer to rely upon the court's conclusions rather than social media gossip. If the court had thought that there had been exploitation of employees by a States member, it would have been a very serious aggravating feature, and the court would have said so. Ironically, the accusation of modern-day slavery is misdirected. If you are a low-paid Jersey person and you want to earn extra money outside your normal employment, you can do so. If you are an immigrant from the United Kingdom, you can also do so. But if you are a low-paid immigrant from Rwanda, you can commit a criminal offence by working for another employer. That is what the immigration rules say. That discrimination, whatever the policy justification might be, is arguably tantamount to modern-day slavery. You are tied to a particular type of employment when a local person is not. And we, not Deputy Ozef, are responsible for that. People in glass houses should not throw stones. How many times are we going to punish Deputy Ozef for his offences? He did let down the States, and he did break the code of conduct. But but punishment should be proportionate. Suspension is a serious penalty. Deputy Ozef's offences were not of violence or fraud or dishonesty or of a sexual nature. They were administrative offences exacerbated by the fact that he was a States member. He did let down the States and break the code of conduct, but he has already been severely punished for what he did, both by the Royal Court and by the States. Let us not demean the Assembly by adopting this proposition. Enough is enough.
Thank you, Deputy. Does anyone else wish to speak on this proposition? No one else wishes to speak. Deputy Tom Binney.
Yes, sir. It's a little bit difficult for me because I don't like speaking without prepared speech, and I haven't prepared anything for today. But I've listened with interest. I listened with great interest to Constable Crowcroft, and I thought he had some interesting things to say, and I think Deputy Bonash has been even more elaborate, and I think he's informed people of things that they may not have been aware of. Deputy Constable Crowcroft mentioned that not many people had been in touch with Deputy Ozef, and I have to make it clear I'm not here to defend Deputy Ozef in any way at all, and I'm not here to pass comments on processes in any way. I'm just speaking as a human being. I have been in touch with Deputy Ozef, and when we talk about Mullard, I really do mean he is Mullard. I've been involved with serious mental illness for many years, and seldom have I seen anybody in such a dreadful mess, and it's difficult to talk too extensively about somebody's ailments publicly, so I'll probably leave it at that. With that in mind, and bearing in mind that all of this would have come to a natural conclusion at the end of March, I can't help but agree with what Deputy Ballas has suggested that we do. I can't help feeling a little bit like I'm watching an episode of Lord of the Flies at the moment. I just think we could have ignored this. I don't think Deputy Joseph would have come in. He is Mullard. He'd have remained Mullard, and this could have been left to die a natural death. As Deputy Ballas has said, Deputy Joseph has been punished by the courts, and I hope that people won't pursue this. So.
Thank you, Deputy. Deputy Scott.
Thank you, sir. I've come from this from two angles, and one has been in terms of what exactly is this sanction for? And I believe that Deputy Ballas has spoken quite eloquently on the matter of already punishing somebody for something that has already attracted punishment. But I know that there's a lot of emotional kind of in this, because there also have been other allegations in terms of the Deputy's treatment of people. Again, I believe that Deputy Ballas has responded to that, because basically using people or employees for a purpose that they're not originally employed for in itself is not actually in itself modern slavery. Let's be clear about that. Modern slavery is something else, and that does need to be dealt with, but that's not what this proposition is about. This proposition is referring to the fact that the deputy has been found guilty of offence and has been sentenced to community service for that. Now, I'm also very much aware of the emotions that can run amongst my own constituents. You know, they may well bay for blood. So the point is, to what extent should I be representing to them, and to what extent should I be thinking there perhaps is a middle way? And one point that I thought was relatively well made was the public should not be paying for Deputy Joseph to be doing community service. Now, I actually think, okay, I kind of understand that. But I want to point out something. He already has been suspended once without pay. So what was this community service? We're talking about 120 hours. So that equates roughly to about 3 weeks. Am I right in thinking he was suspended for a period of about 4 weeks without pay? Yeah.
Would the member give way?
Yes.
Yes, if you want to clarify something.
The member was looking at me, but the member was suspended for the speeding offence, and then as a result of that in here for 28 days without pay. And I was going to actually ask the member how she voted on that.
So just to answer, I didn't support that because the deputy had already been punished by a court, and I don't believe that the States Assembly should be doubling up on punishment when that's already been considered by the authority that under our constitution we think is appropriate to dispense justice. However, I do accept that that was the punishment given by the States Assembly. So I believe that the deputy has already been suspended in a way that compensates for the fact that he is on community service. Anyway, I will continue to wait to, any more arguments in this way, but I'm not 100% persuaded that I should join a crowd. I accept that I would like to have seen the deputy resign for a number of reasons. He's not been well enough to perform his duties. I believe that he has the probably the resources, I may be wrong, to be able to survive without that. On the other hand, he has been ill. So, Sir, I will await for other people's contributions, but I do, I just wanted to make that particular point.
Thank you, Deputy. Does anyone else wish to speak on this proposition? Deputy Rob Ward.
Thank you, sir. I've not spoken in these debates before because I don't really want to have them. I believe that the deputy should have resigned. This was a court case. And I just read a couple of things from the court case itself, paragraph 14. In relation to the deputy, we agree with the court that your position as a senior politician is an aggravating factor. As a lawmaker, you're well aware of the need for controls of the nature of the work carried out by those entering the island and the need for those to control to be obeyed and enforced. When those controls did not suit your purpose, you chose to evade them. That's a very significant ruling. We are states members, we are elected to represent people, and we have a huge high expectation of our behaviour. When that behaviour is of a situation whereby you are sentenced in court to, and the court sentence says 120 hours or equivalent to a 6-month sentence of imprisonment, if that imprisonment had happened, regardless of who the person is, let's look factually about the ruling and what that means for us as a States Assembly. We are saying, well, you know what, it's okay if you get imprisoned, carry on, come back when you're out of prison. We can just carry on with this. I'm afraid we cannot work by those rules. A prison sentence would have meant automatic removal from this Assembly. Those are the facts behind this. I, too, of course, this notion of it's not about a pound of flesh, it's about the integrity of this Assembly. Are we going to say that if somebody commits an offence, a senior politician who was Minister for External Relations, our front-facing minister to the rest of the world, and I'm afraid we have to say that, regardless of who the person is, another had this position in our Assembly, another committed this offence, another was found guilty of this offence and pleaded guilty to this offence. These are the standing orders. Should we suspend? Unfortunately, the answer is yes, we should. Now, I understand if people have a difficult time in life. Many people go through difficult times in life. The advice would have been to resign and get the help that is needed. It has been offered a great deal by the GREF, and I think that a lot of support has been put in place. But today we are talking about the integrity of us as members of this Assembly. And I put myself in this position. What would I have expected? I would have expected to have resigned. And yes, I would have found it extraordinarily difficult because this is my income. I don't have additional income. I don't have other things that I do. But I would have been expected to do that. So this is not a personal vendetta. We should not be debating it in that manner. We should be talking about the integrity as us as state members. As a states member, I go to other jurisdictions and talk as a states member, a representative of Jersey. And I'm afraid that when we cross the lines in terms of our behaviour, we have to step up to the plate and take that responsibility, with or without whatever's going on in the background. And I think not suspending is not just about, and I find it odd that we're talking about popular decision. It's not a popular decision because we've all suffered from the fallout of this and the integrity of us as politicians. And that phrase, oh, you politicians, you're all the same. And I find that so unfortunate. So I will support this, and I will support it not because of the personal, but because of the factual process that we have to go through as states members. What do we expect of any states member? The person sat next to you. What do you expect? And if it's not met those expectations, then I'm afraid this is the outcome that we have to do. And I support PPC in this, and I think it's good that we've taken it today. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on this proposition? Deputy Moore.
Thank you, sir. I simply rise to provide a little fact on a point that seems to be concerning members of this assembly, and I would imagine also members of the public also. And I have permission to share this information, but if it provides any assistance or comfort to members, I can inform you that the Deputy has not received a salary since his sentencing. That was at his request, and I think that it's helpful that members are aware of that. Sir, there are many other things that can be said, and I don't wish to prolong this at all at this point. But I, somewhat like Deputy Balash, agree that, I think that the simplest way of putting my perspective on this is that Deputy Ozef and I, as members will know, have been friends for a good long time. We obviously don't agree on all matters, and there will be elements of this situation upon which I find differences of opinion. However, one area where we certainly don't agree is the separation of powers. And so the job of justice is in the building next door to us, and the job of setting the rules is ours as a legislature. And I'm very aware of that in this debate. I absolutely agree with members about the optics and about the standards that we expect of each other as representatives of the public. I feel that very keenly indeed. And Sir, apologies, and Sir, I just counsel members to consider that the Commissioner for Standards, as far as I am aware, has not yet opined on this matter. I don't know whether it is under her consideration, but her view has not been heard, and that is the proper process upon which we consider our code of conduct as far as I am aware. And with that, I thank members for their time.
Thank you, Deputy. Deputy Barbara Ward.
Yes, thank you, sir. Just a point of clarification. I was under the impression, and I may be wrong, that estates members weren't allowed not to take our salary. I would like some clarification on that. Am I correct in my understanding, or am I totally wrong?
I hesitate to correct a factual matter that has been raised by a member. Although it may have been the wish of Deputy Ozef not to receive a salary for the recent period, my understanding from the greffier is that he has continued to be paid, notwithstanding that may have been his wish, and the only, so far as the gref is concerned, guaranteed way of preventing payment is suspension. I'm just relaying what I've been told by the greffier. If that answers your question, Deputy Ward.
Thank you, sir.
That's what I've been told. Does anyone else wish to speak on the proposition? Yes, Deputy Taddeo.
So I think we need to bring this back to basics. The first spurious example that's been given here is that because it's been dealt with in the court, we don't need to deal with it. And this argument was made during the debate of P64, which was the debate to suspend Deputy Ozef for 28 days following his speeding offence, which resulted, I think, in a fine, and there were some other, and there was a breach of the code with that. 29 members supported it, 17 voted against, and 3 abstained, sir. The States Assembly is separate to the courts. This is the separation of powers. We are our own separate body. We have our own rules. We have our own code of conduct. Whilst this may not have been referred to the Commissioner for Standards, and that's largely, I think, due to time constraints and also the fact that there weren't complaints, this is a de facto breach of the code. And we did raise this, and I made sure that when it was discussed over a month, certainly last month at PPC, I said, look, before we proceed with this, are we all in agreement that this does represent a breach of the code? So we're not just bringing this because the court's dealt with it, we're saying that this is also a breach of the code and that we're all satisfied. And it was unanimous around the PPC committee from those who were there that the behaviour and the resultant sentence in the court had very much brought Deputy Joseph's behaviour to be scrutinised under the Code of Conduct, which we'd done, and that he'd breached the code on various counts. Clearly, if he's breached the code for speeding down a green lane by doing 15 miles an hour and got fined for it, then he's also breached the Code of Conduct for illegally employing 2 Rwandans in Jersey who didn't have the right to work for him. And we know about that, and it was in court for on the front pages, and it took months to deal with that. So I don't think there should be any doubt in anyone's mind that this shouldn't be dealt with by this Assembly and that it was a breach of the code. Now, the question, therefore, given the fact that we have an absolute, not just right, but a duty to deal with this under our own code, because we're not the Royal Court, and the fact that it is a clear breach of the code, I would say, then those 2 items, those 2 facts, should be sufficient for any member in this Assembly to put aside their personal feelings for Deputy Joseph, irrespective of their long-standing ministerial colleagues, of Deputy Joseph who might feel a bit bad having to vote for this today, sir, because they might have to justify that decision to him. I think there is also a part of the code which says where there's a conflict of interest, and I think this is a conflict, not a financial one, it's an emotional conflict, isn't it? So I think we're thinking about this thinking, I'd feel really bad if I had to justify voting to suspend Deputy Joseph when he's a long-standing friend, he's a long-standing colleague, he's a long-standing political ally of mine. But the code says that we should resolve the conflict in the public interest. And where is the public interest best served in this? Irrespective, take out the fact that this is about Deputy Joseph. As Deputy Ward said, this is about Deputy AN, other, Constable AN, other. And I think we just have to go through the process, and this is very much what PPC has done. So I think that's really all that needs to be said on this issue. We can get into the emotions of this. We can say that, as I said before, that this wasn't a victimless crime. We can get into the fact and say that actually Deputy Joseph was in a very fit and healthy state when these offences were taking place. I believe some of these offences took place whilst Deputy Joseph was actually a minister. There may be questions in the future about which ministerial colleagues of his at the time knew about what was going on. There are questions, of course, that could be raised about whether or not these workers were used to put up election posters and whether those expenses were declared, which it should have been. But that's not the focus of today's debate. So I'm happy to give where I see a light on.
No, thank you, sir. I just wanted to ask the Deputy what makes him suggest that States members are being guided by emotions of protectiveness and towards Deputy Joseph rather than are just trying to have an objective view of this matter, bearing in mind that I do believe that modern slavery is a motive subject, but the actual emotions the Deputy were referring to was some sort of emotion of protecting a colleague.
The reason I believe some members are being led by emotions is that because we've heard speeches earlier which said let's consider the well-being and let's think about the feelings of Deputy Joseph. This is not very nice for him. The point is this has not been very nice, as I said earlier, for those individuals who were subject to those workers who were in a vulnerable position and who ultimately were the result of the victims in this court case. I don't think this is a victimless crime. So the point here, sir, I go back to the 2 simple points. Has the Code of Conduct been breached? Yes. If there are members in the Assembly who have not yet spoken who don't think that his behaviour represented a breach of the code, they need to stand up and say that now, because let's have the alternative side of the argument that Deputy Balash said. If we are all in agreement that the code has been breached, the next question on the flow chart is, do we then deal with that breach by voting for a suspension which is proportionate? And I think the answer again has to be yes. We don't start the question by asking who is this relating to and are they signed off Malad today? So I think we'll be in a situation where that just continues, as I've said previously, on and on, sir. So this is a tough decision that we have to make, but it is about upholding our code of conduct and holding ourselves to the highest standards, sir. And it doesn't matter whether that's Deputy Ozef or whether it was Deputy Mezek or Deputy Feltham. I look at the front row. If they were my party colleagues, we'd have had that conversation a long time ago. First of all, saying that as soon as the matter was in court, there'd have been a neutral act to suspend them from the party. As soon as they were found guilty of that, if they hadn't stood down before, we'd say, I'm afraid you've lost the party whip now. And then the advice, of course, behind the scenes would be, look, you are my friend. And I think because you're my friend, I'm going to tell you some home truths. And it's time to go. You need to take some time out. But, you know, on a personal level, I'll be here for you. But politically, I'm afraid that you have to do the right thing and stand by your integrity, sir. And that should apply to any member of this assembly, irrespective of who they are.
Thank you, Deputy. Does anyone else wish to speak on this proposition? Deputy Gorst.
So I want to move further up the flow chart that Deputy Tedder just referred to. And of course, he's absolutely right. The flow chart doesn't start with who's involved. And it shouldn't. And I have not heard any case this morning on either side of the argument that suggests that that's where the flow chart does start. So I voted in favour of Deputy Balash's proposition to defer this until the 24th. And I did so quite simply because I believe it's a matter of fairness. Whilst, of course, the Connétable of St John is absolutely right that Jacks would say that you could remove someone from employment in their absence or whilst they were ill, and the UK legislation allows for the same, one wouldn't, in my experience, do that only after the second point where you could have done it. There would be engagement with the individual, there would be medical support for the individual, and only after you had exhausted all of those avenues would you then actually take the decision in absence of the individual. It's difficult for this assembly to follow those processes. To some extent, we have to outsource that to the good offices of the GREF, but the GREF isn't the employer either, and we find ourselves in a difficult situation. But for me, I refer back to what the Connétable of St Helier said. It isn't fair for us to deal with this matter today. We are now dealing with this matter today and understand why PPC have done so. But for my part, that is the first question in the flow chart because the person is absent. And therefore there has been and will be no right to reply. Thank you, sir.
Sir, can I ask for a point of clarification?
Prepared to give way to point of clarification?
I certainly will try, sir.
Yes.
Sir, the Deputy spoke about dismissal, sir. This debate is about suspension. Thank you, sir. Would the Deputy agree?
Technically, the Constable is absolutely right. In practice, it will mean the same.
Thank you. Deputy Breniff.
Yes, sir. Thank you. It is a very difficult situation we find ourselves in, and the question of the personal situation in which Deputy Ozef finds himself is a significant factor, and I take very seriously the words of Deputy Tom Binet and Deputy Moore, amongst others, in relation to that. The Deputy has been dealt a terrible hand in his personal life, and for that I do have enormous sympathy. That is not crocodile tears. But in terms of the situation regarding his legal issues, the question has been asked, why are we in this position? Why are we dealing with this situation today? And I think the thing we have to face here is that the deputy has made choices. This situation need not be debated at all if the deputy had removed himself from this assembly, as any other member, I think, would have done. That is a conscious choice by the deputy. He has been urged by multiple people to take that course of action. He has chosen not to do so. That is a significant fact, which is the reason why we are debating this, when we would rather all not be debating it. There is a considerable sense in which the deputy has made choices here, first of all, to commit criminal offences, and secondly, to not take the action that would normally be expected of you in a situation like this. And as I said in my earlier speech, the risk is that that by not taking action today, we would be normalising the kind of behaviour that in normal circumstances we would regard as completely obvious what should happen. I think the question of modern-day slavery, which Deputy Balash raised, is a bit of a red herring. The issue here is not about the details of the court case, and as others have said, the question here is about the code of conduct, the entirely separate matter of whether or not the code of conduct has been breached. And I note that Deputy Balash said very clearly it has been breached. I don't think anybody has advanced the case that it has not. Therefore, the only question is about the appropriate sanction. And I think that a 28-day suspension in the case of a criminal prosecution of this kind of magnitude, where the courts heard that the deputy had deliberately set out to, as the quote from the court proceedings read by Deputy Rob Ward said, there was an intent in this. And I think in those circumstances, a 28-day suspension feels like the minimum, frankly, that the public would expect in those kind of circumstances where we have the responsibility to uphold, it's written into the code of conduct, we have the responsibility to uphold those standards and to ensure that they are upheld by others. That's in the code. So I think that the case here is pretty clear-cut, and the only reason why it's being debated at all is because the deputy has chosen to stay in the firing line. And I think in those circumstances there's no hesitation really in supporting a suspension.
Thank you, Deputy. Colin Talbot, St Martin.
Thank you, sir. In Deputy Balash's speech, he mentioned that the victim's personal statement from one of the individuals working for Deputy Ozov said that she still owed money for the work she carried out. So I would say that she probably was still suffering. It has been mentioned several times in this debate that this has not been very nice. It's not nice to be discussing this. And no, this is not very nice for anyone in this whole assembly. I do feel for Deputy Ozov that he is suffering with his mental health. And I believe that the whole assembly feels this way. We do have compassion, and I did take real exception that it has been mentioned that this assembly, if we vote to uphold standards, are vindictive or baying for blood. I am certainly not vindictive in this, and I am not baying for his blood, and I do have, this is not crocodile tears, I do have complete sympathy for the deputy, and I spoke to him several times when he was in the assembly, and he was suffering with his mental health, but this is something that he actually brought on himself. He was a minister, I believe, at part of the time or the whole time when he did this. He is a very intelligent man, so he would know what he was doing. So as I said, I do have compassion, and I find this debate extremely uncomfortable, and it's something that I wish we didn't have to discuss. It's not fair actually, on all the members in this assembly. Deputy Moore said that we set the rules in this assembly, and this is true. We have a code of conduct and we should follow it, however difficult. We need to set a standard as we are public figures, and the person we are sanctioning was a minister. And as I said, he is an intelligent man. I do feel desperately sorry for him that he is suffering with his mental health. But when do we stop? When do we decide that we don't need to set standards? We really do need to set a standard, and I find this really difficult. I wish that we weren't all debating this. It's not something that I can, it's not easy for anyone in this assembly. And I think it's not just the victim here. It's not just the member that we are discussing here who is suffering. I think a lot of us in this assembly have found this so difficult. And he should have resigned. And he did this as an intelligent man when he was a minister. So I think we need to bear that in mind. Thank you, sir.
Thank you, Conor Tarb. Deputy Mezek.
Thank you, sir. This debate and the wording of the motion has Deputy Oziff's name in it, but it's actually about a lot more than just Deputy Oziff. It's about the whole public of Jersey, and it's about our political system being fit to serve its purpose of facilitating the betterment of our whole society and making the people we represent happier and more prosperous. And whatever your position on the rights and wrongs of any particular element in the argument about whether Deputy Oziff should be suspended or not, we, I think, need to remember this fact, which is that not a single one of us in this chamber has the right to be here. We are only here because of a temporary privilege bestowed upon us by our constituents, insofar and for so long as their judgment is that we're capable of carrying out the functions of a states member to the standards that they wish to see from us. And when they no longer have that confidence in us, it's time to go. And when that happens, we have no right to complain about it because it is only a privilege to be here. Whatever your positions on the rights and wrongs of any element of this argument, is there a single member of the Assembly right now who's prepared to stand up and say that Deputy Oziff is currently capable of carrying out the functions of a states member? He's not, and so he shouldn't be a states member. He's not able to represent his constituents. He's not able to contribute to the proceedings of the Assembly. And there's lots of reasons for that, and some of those reasons we can have a great deal of sympathy with him for, others we can't. And that is why he should have resigned from office, because it's not about him, it's about the public, and it's about the system and the system's ability to serve its purpose of making islanders happier and more prosperous. And in the absence of him having done that, we're now spending hours on a Tuesday morning when there are lots of other issues that we ought to be focusing on that do focus on the betterment of our society and making people happier and more prosperous. We're debating and spending time talking about excluding him from a process that all of us know he's not currently capable of taking part in anyway, irrespective of what we decide with this motion. So we're here debating this because Deputy Oziff hasn't done the right thing and resigned from office and accepted the fact that he's not capable of carrying out the functions of a states member. And so this motion is here for the Assembly to at least acknowledge the point that everyone out there in the public already knows, which is that he shouldn't be taking part in these proceedings and shouldn't be acknowledged as a states member because of the convictions that he's had. In most people's eyes, will see him to have lost his right or his privilege to do that. So, sir, this matter doesn't need to be controversial. I certainly don't think it's controversial out there, where the public would prefer we weren't spending time on this, but we're having to, and we should pass this motion so that Deputy Oziff officially will not have any right or ability to carry out the functions of a states member or receive remuneration for something that he's not doing in the meantime. And I think, sir, that that's very basic. And it's not just about him, it's about the public, it's about the system, and sir, it's about his victims, for whom it has been disappointing to hear some members sound like they don't have particular regard for that, but it is an extremely important factor in this. And so it's not mentioned in the proposition itself, but because of everything that's come to light from this, we have discovered that Deputy Joseph submitted a fraudulent election expenses return because he was receiving help from people that the remuneration for whom ought to have been noted in his expenses but wasn't noted in his expenses. So there's an argument to say he shouldn't have been here in the first place, and those standards matter. And to say they don't matter is to open the doors for all sorts of other behaviour that we shouldn't be prepared to contend with in our politics. So I think it's vital that the Assembly supports this motion.
Would you accept a point of clarification from Deputy Scott?
Yes, sir.
Yes.
Thank you, sir. Because the deputy referred to the position that we have as representatives, and obviously there is no currently recall mechanism, and the PPC hasn't supported that. So I just wondered if the deputy has actually received any communications from constituents in St Clement's themselves in respect to this matter.
Well, I'm not sure whether that would specifically be St Clement's, sir, but every single person who I have spoken to on this matter supports this motion. And I think if you did any kind of poll, I think the evidence would demonstrate that across all 12 of our wonderful parishes.
Thank you, Deputy. Deputy Doublé.
Thank you, sir. I'm trying to gather my thoughts on this, and I too wish to not spend too much time on this because we've got so much to do. And the Constable of St Helier asked members if we had visited the deputy, and I have not, purely because I'm very busy trying to do the work that I've been elected to do. But nevertheless, I do have great sympathy for the deputy. And as other speakers have mentioned, I think we can hold that compassion and still require that some sanctions be made. I wanted to mention some of the other things that were said, and a previous speaker, I think in the debate to move this to the next sitting, mentioned that the crimes that the deputy has been found guilty of, that there was no violence involved. And this struck a chord with me because actually the people who were the victims of those crimes are very likely to be experiencing something called minority stress. And this is a psychological phenomenon which actually means that chronic discrimination, exploitation, microaggressions, institutional barriers, etc., that are faced by minoritized communities or marginalized groups actually has a physical impact on them. So I don't think we should dismiss this as something which is not impactful, because I don't think we can actually know what the impact is because those people aren't in the room. It's minority stress theory. I can see one of the deputies looking confused about that. And so the fact is, again, as other speakers have said, that we are held to a higher standard of behaviour than the average citizen. And I think that what we need to do is actually just make a decision on this today. And I think we can do that while still holding compassion for the deputy. I think both things can be true. I think we can feel compassion in both sides of this, and I think we can act decisively and fairly. And I do think it is fair to suspend the deputy. I think that, to me, seems a reasonable and fair thing to do, considering the harm that has been caused. And there will be harm, of course, that we're not aware of, because the threshold for conviction in a court of law is very, very high. So there will be harm that we're not aware of. And I wanted to be very, very clear that I stand with the Black community and that I see those sometimes unintentional harms that are caused to that community and to other marginalised communities such as the LGBTQ community, that actually as states members it's our responsibility to educate ourselves on minoritized groups, and it's our responsibility not to cause that harm. We have to actively educate ourselves and actively take actions not to cause that harm. That's the highest standard of behaviour that we sign up to when we take on this role. And yes, those expectations are high, and they should be. So I'm not going to remain a passive bystander, sir. And actually, if you look in our code of conduct, there is actually a line in there which is about allyship and not being a passive bystander. And we are all, I think Deputy Renouf pointed this out, we are actually all bound by that code of conduct to notice exploitative, abusive, or harmful behaviour and unequal power dynamics where that is occurring, to call it out and to act accordingly. So I will be complying with that code of conduct that I have signed up to, and I will be maintaining those high standards today, sir.
Thank you, Deputy. Does anyone else wish to speak on this proposition? If no one else wishes to speak, I call upon the Chair of PPC to reply. Chair.
Thank you, sir, and I thank members for their contribution. I understand how difficult this debate has been for members. Deputy Balash mentioned that suspension is a serious penalty. I believe it is, but of course Deputy Ozef has committed a serious offence. Deputy Moore mentioned about the salary, which I believe has been clarified. As I understand it, he has received his salary apart from the previous 28-day suspension, which was imposed by the Assembly. And on the Commissioner for Standards front, I'm unaware if the Commissioner for Standards has received any complaints to conduct an investigation, but that process takes a good deal of time, and it wouldn't be completed if it was taking place until after the end of this term. When we debated Deputy Ozef's suspension in September 2025, in my summing up, I spoke about the importance of us demonstrating to the public that we hold each other to high standards of behaviour. A single transgression damages the public trust, not just in an individual member, but also in the Assembly as a whole. This is an opportunity to signal to the public that we care about the reputation of this Assembly, and we can be trusted to do what is right. Sir, I maintain the proposition and call for the appel.
Thank you, Chair. The appel has been called for. Members are invited to return to their seats. I'll ask the greffier to open the voting. All members.
So my voting button is not working, I'm afraid, but I obviously vote against.
So we'll put you down as a cont. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can announce the proposition has been adopted. 34 votes for, 5 votes contra, and 6 abstentions.
Move the 5 and the 6, please, sir.
Yes.
Those voting contre, the Connotab of St Helier, Deputy Labby, Deputy Rose Binet, Tom Binet, and Deputy Balash. And those abstaining, the Connotab of Trinity, and Deputies Gorst, Moore, Wall, Scott, and Wilson.
The greffier will preside over the next matter.
So the next item is the draft alcohol licensing Jersey Law 2000, P112 of 2025, which was lodged by the Minister for Sustainable Economic Development. The main respondent is the chair of the Economic and International Affairs panel. The debate resumes in second reading following the adoption of the principles on the 22nd of January 2026 and a referral to the Economic and International Affairs scrutiny panel. There are a number of amendments that have been lodged. There is a running order, and there are hard copies of the running order over here in the corner, I think, for anyone who's wishing one, but also some on the desk, so if people want to indicate, they can be. Can I just double check that that is them before you hand them out? Oh, those are copies of the law, as it would look like if the amendments were adopted. So we've got copies of the law, but the running orders, Assistant Graphy, are on the desk there. So those who want them, they can indicate. So we all have a fighting chance of knowing the direction of travel. So without further ado, Minister, how do you wish to propose the articles?
Well, I'd like to propose the articles in the second reading. I understood that we started with Deputy Balash's amendment first, so I wasn't planning to speak at this juncture, particularly other than to propose them in the second reading and to move into the amendment debates.
Very well. We will start with the amendment that is brought by Deputy Balash. But first and foremost, if I can ask the graphier to read the proposition. Just start with the yes, yeah. It's a very long amendment. I wonder if members would be willing to accept the amendment as read, rather than requiring it to be read out in its entirety. I think that would be, if that's acceptable.
Madam Chair, I thought that the procedure which the Deputy Greffier had outlined involved the Minister proposing.
I did invite the Minister to propose the articles.
In second reading, following which the amendments will be dealt with.
Well, I invited the Minister in the first instance to propose the articles, and you can make your speech now.
Okay. Thank you, ma'am. Yes, I would like to propose the articles in the second reading. There are a number of amendments. There's one from Deputy Curtis, one from Deputy Balash, one from myself. It is my intention to accept Deputy Curtis, or to support Deputy Curtis's amendment. Obviously, I'll be supporting my own amendment. My amendment changes the, if adopted, would remove the Alcohol and Gambling Commission from the law and would put the administration of the law under the Regulation Directorate, which is part of the Environment and Infrastructure Department, the Environment Planning Department. But I do not support Deputy Balash's amendment. My understanding of the running order is therefore that I can't propose as amended by mine or Deputy Curtis's amendment. So we have to go through all the debates, which is why, otherwise I would propose it as amended by Deputy Curtis's and my own amendment, but that's not possible. So my understanding of the running order is we hear Deputy Balash's amendment, we vote on Deputy Balash's amendment. If his is passed, then amendments 2 and the next 2 amendments fall away. That would be mine, and then we would move just to Deputy Curtis's amendment, I think. If Deputy Balash's amendment is not supported by the Assembly, then we would move on to vote on my own amendment and Deputy Curtis's amendment. So the important one to get through, and the one which, and this is not in any disrespect to the amendment itself, but the one which stops us reading it as amended from the bits that I personally support, is Deputy Balash's amendment. So I do ask if we could move to Deputy Balash's amendment, and I propose the second reading.
Thank you, Minister. Is the Assembly content to take the amendment as read, rather, or would you rather?
I think we'll just second the.
Oh, sorry. Is the article seconded? Thank you. Is the Assembly content to take the amendment as read? Yes. Thank you. Then I call upon Deputy Balash to speak.
Madam Chair, this morning a document landed on my desk presented by the Economic and International Affairs Scrutiny Panel, which I was surprised to see made a passing reference to my amendment, but otherwise did not deal with it at all. Nor did the panel's comments touch upon the quite lengthy response which the Licensing Assembly gave to the questions which had been posed by the scrutiny panel. I think that is disappointing. I think that it would have been more helpful to the Assembly had the panel dealt with both the amendments and their respective points of strength and weakness, but there we are. So may I begin by asking rhetorically why we are proposing to dispose of the Licensing Assembly. I have heard no one say that it does not work, subject to the restrictions of the 1974 law, efficiently and fairly. Even the Minister, I think, concedes that. So why mend something, as was said on the last occasion, when it ain't broke? Or to use another metaphor, why throw the baby out with the bathwater when the bathwater is the 1974 law and the baby is the Licensing Assembly, which at present is alive and flourishing. The Assembly is not arguing, the Licensing Assembly is not arguing that it should maintain its functions, but it has expressed its willingness to continue to serve the public, and any suggestion that it is unwilling is mistaken. The Assembly is not the Royal Court. It is true that it is composed of judges of the Royal Court, but it is a separate body with a different and discrete function. The States Employment Board is composed of members of the states, but it is a separate body with a different function from the States Assembly. The broad purpose of this amendment is to maintain the function of the Licensing Assembly as the body which determines liquor licensing applications. In broad terms, however, it adopts the principal changes sought by the Minister, so that the Minister, with input from the Alcohol Policy Group and the States Assembly, will settle the policy guidance under which the Licensing Assembly will operate. There has never been any question but that the Licensing Assembly was willing to accept such guidance. As long ago as the 10th of May 2022, the bailiff, Mr. Lecoq, as he then was, stated, and I quote, "The Licensing Assembly is entirely mindful of the resolution of the States Assembly that it would take over policy, and we would wish that to be the case and have no difficulty with it." But until now, in fact, even now, there is a vacuum. There is no policy guidance. The problem of inequities in licence fees can be addressed by the Minister, who has the power to set fees by order under this amendment. The problem of infrequent sittings of the Licensing Assembly has been addressed by constituting it with a president and 2 jurats, imposing an obligation to sit at least once a month and empowering it to sit on other occasions too. The Minister's amendment proposes that the functions of the Assembly should be taken over by the Regulation Directorate, which sounds a grand body, but is defined as being a civil servant, the chief officer or equivalent of the part of the department responsible for the regulating of the sale of alcohol. The states therefore have a choice between these two amendments. The functions can be fulfilled by the licensing assembly, as at present, or by a civil servant. There are three principal reasons for preferring the assembly to a civil servant. The first is that the assembly is composed of judges, both lay and professional, who are experienced in reaching difficult decisions, balancing competing interests, and reaching fair judgments on controversial issues. And let there be no doubt that some issues are controversial issues. When, for example, an applicant wants to establish a nightclub in an area where people live, it is controversial. The main task of civil servants in the Minister's Department is to boost the economy. That's different from deciding an application where the economic interests of the applicant are only one of the factors to be considered in making the decision. While I'm sure that the relevant civil servant would be competent, he or she would not have the experience of the jurats, nor, I suspect, would there be the same level of public confidence that an impartial decision had been reached. Secondly, the Assembly sits in public. Its processes are transparent. There is no suggestion that the Regulation Directorate would conduct a public hearing. Before the Assembly, applicants have a right to make their case openly, and objectors have the right to be heard. A decision is given in public with reasons. A process by a civil servant behind closed doors would utterly lack that transparency and obvious impartiality. It might be fair, but it would lack the appearance of fairness. A single civil servant deciding on the papers is quite different from a body of 3 judges deciding in public. I'm sure the Minister would not allow himself to be lobbied on an application, but the civil servant might nonetheless well be influenced by what he perceived to be the Minister's wishes. Thirdly, there is the question of cost. The jurats are not paid. The Minister's amendment states that there are no new financial or staffing implications from his proposal, but I must say that seems highly unlikely and probably reveals a misunderstanding of what the Directorate will actually have to do. It is said that the Directorate already manages the administration of the law, but dealing with the grant or refusal of applications is an entirely different function. The Minister describes the change in his report as, and I quote, vesting the oversight of alcohol licenses in the Directorate, unquote. But it is not just oversight. It is much more than that. The Directorate will need to ensure that all necessary reports are available and to study them. It will need to consider whether to attend the parish assembly and whether to speak. It will need to consider the outcome of the parish assembly and weigh that in the balance. It will need to consider any objections that may have been made. It will need to think about the alcohol policy framework and apply that. It will need to think about the nature of the business and the suitability of the premises for that kind of business. It will need to think about the public interest and where that lies. All that for the Directorate is entirely new. It is not done by the Directorate now. I would be astonished if there were no resource implications. The Licensing Assembly indeed has estimated to the scrutiny panel that 3 extra staff would be required by the Directorate. And finally, will the same civil servant deal with all aspects of the process? It seems from the scrutiny panel report that the answer to that is no. And if so, can we be sure that the ultimate decision maker takes all the relevant considerations into account when other officials have dealt with other issues? None of those problems arises if the Licensing Assembly is retained. What we would be doing is to convert what is a transparent quasi-judicial process into an administrative one performed essentially behind closed doors. We are giving a significant new power to an already very powerful civil service. I don't think that that is in the public interest. There has been no public consultation on this aspect of the proposed change. If people knew about it, for my part, I don't think they would be very happy. The Minister does make a valid point about streamlining and integrating the alcohol licensing administration with food safety, hygiene, and consumer protection. But that has little to do, it seems to me, with the process for granting liquor licenses. It can be done even if the Assembly remains the license granting body. There are 3 other points perhaps worth mentioning. The first one is that the proposed Article 3 gives the Licensing Assembly power to delegate any of its functions other than the determination of licensing applications and the suspension or revocation of a license to the constable. This is obviously for further consideration, but it is a matter that was discussed with the Comité des Connétables, and it seems to me that one of the functions that might be delegated to the constable might be the registration of managers. There may be other functions which could usefully be delegated to the parishes. Article 11, secondly, deals with the division of fees. And although in discussion with the Comité des Connétables, there was an expression of the wish that the fees should go exclusively to the constables, it seemed to me on reflection that it was better and more administratively convenient that the minister should set the fees, but that he should be given a discretion, and indeed the law encourages him to exercise that discretion by sharing the fee income with the parishes. And thirdly, the provisions for civil financial penalties have been deleted. The Licensing Assembly has the power to impose fines, and that is perfectly sufficient. Finally, I would say that the Licensing Assembly has exercised this function successfully for hundreds of years. It has shown itself to be competent, independent, and impartial. No substantial case has been made to replace it. The baby should not be thrown out with the bathwater. the only part of the Minister's amendment which I would have accepted had I been able to do so, is that part concerning the alcohol policy framework. I agree that it should be put into law, but unfortunately the Minister included that in his proposals only after I had lodged my amendment. However, it would be a simple matter to bring a further amendment in due course, and I ask members therefore to support this amendment.
Is the amendment seconded? I then open the debate. I have the Conotub of St Helier as the first speaker.
Thank you, Ma'am. I'm pleased to support Deputy Balash's amendment to the law. It's good that the Minister has replaced the somewhat illogical choice of gambling control, and I mean no disrespect to the good people who work for it, but it I think always struck many of us as quite illogical to give licensing over to gambling control, and I'm pleased he's replaced it, but is it any different to give the important task to, again, I mean no disrespect to the persons who may do this job, but to a faceless bureaucrat? Deputy Balash, in his very good opening speech, I think, made it quite clear that there is not much protection and zero accountability involved in the proposed transfer of this responsibility. I suspect, Ma'am, that there are two driving forces behind members who wish to oppose Deputy Balash's amendment. The first one is ideological. There are members who would like to see the role of the bailiff and the judiciary with regard to political life in Jersey diminished. And for those people, I have some sympathy. Members may remember that I myself suggested that we could replace the President of the Assembly with an elected member, and it's personally a belief which I still hold. But that doesn't lead me to feel that the licensing bench should be replaced by a faceless bureaucrat. I think the other reason, not ideological but more pragmatic, is that there are members, perhaps particularly in the Council of Ministers, who want to spare the blushes of the Minister for Sustainable Economic Development and give support to his amendment. And I think that would be a shame, because this is an extremely important matter. I have stood in the licensing bench probably more than anyone in this Assembly, except perhaps the mover of the amendment, who of course would have chaired it many years ago. But I haven't counted up the number of times. I was in the licensing bench only a week or so ago, hearing an extra application which had been brought to the parish assembly and then on to the licensing bench. And I was struck as I stood to give the parish comments that the system really is very effective. It is, as Deputy Balash said, it is held in public. It is held before learned durats drawn from many walks of life. It allows the public to be there to speak for or against the application. And it gives the applicant the chance to actually be seen and to meet the people who are going to be approving, hopefully, and most of them are approved, their application. It's no accident, I suppose, that where the Conotubs sit in the Royal Court for the licensing bench is but a few inches away from where people stand in the dock when they are in trouble. And of course, people can be in the dock quite frequently because they're in trouble with alcohol. And we know that we have a real problem as an island with alcohol abuse, and it has many effects. And most importantly, I suppose, is we know that it is very important in domestic abuse, where the abuse of alcohol is frequently adduced as a reason. It is also, and again very regretfully, often responsible in part for antisocial behaviour and, even worse, crimes of violence and assault, particularly, though not exclusively, in St Helier. So there's something rather appropriate, I feel, Ma'am, when I stand in the licensing bench and I give the support of the parish, which has been communicated through the parish assembly and often by other communication to the constable. And I support that because it is a judicial process, and everybody knows in the Royal Court that if you get it wrong, it's a serious matter, and you could wind up in the dock. There have been a number of applications, not many, thankfully, but there have been a number of times when the judiciary has had to take away licenses from establishments where the rules have been broken. Representations have been brought by Crown officers to suggest that a sanction should be placed on a particular establishment. I'm obviously not going to name names, but members may be aware of some of these offenders. And it's a very powerful reason why landlords and holders of licenses really do take it seriously, because they know that at the end of the day, if they get it wrong, and if they continue to get it wrong, there may well be a representation in the Royal Court that will deprive them of their license. So, Ma'am, I believe, with the proposer of the amendment, that the system we have at the moment works really well. It protects the applicant and it protects the public. And although I won't lose any sleep if Deputy Balash's amendment is lost, because there is still time for the next assembly, I believe, to revisit this whole matter, and it probably should. I may lose sleep literally because as a St Helier resident, I live on one of the streets frequented by people who are sometimes staggering home from licensed premises, having had too much to drink, having had too much noise, and they're bellowing into their phones or bellowing at each other. And I do, as all residents of St Helier do, and other outlying parishes, suffer from the consequences of when people get licensing wrong. And so I would urge members to keep the system that we have, because it does bring gravitas, it brings necessary sanctions to the very important and responsible task of holding an alcohol licence. Thank you, Ma'am.
Deputy Morell.
Thank you, Ma'am. I thank Deputy Balash for his amendment and the Connétable for his speech. It will come as no surprise, Ma'am, that I won't be supporting Deputy Balash's amendment. And I'm going to start speaking by asking a really simple question of the Assembly, Ma'am. Why is alcohol licensing, the licensing of restaurants, the licensing of bars, licensing of hotels, why is it a judicial process? Why is it the preserve of the judiciary? It seems a very odd thing. The judiciary is there to interpret laws, Ma'am. It's there to resolve conflicts, to protect rights, and, importantly, the judiciary is there to check the other branches of government. It is not there to do licence applications. Never really has been. What we have, as Deputy Balash said, hundreds of years of the licensing assembly is hundreds of years of the judiciary ruling Jersey, Ma'am. And that is something which over the past century is something that Jersey has moved away from, to become more democratic and to ensure that the judiciary sits in the appropriate judicial lane, where it will be interpreting laws, resolving conflicts, protecting rights, and checking other branches, but not actually opining upon licence applications, which if actually, effectively, are just business licence applications. What the judiciary is there to do is, when there is a dispute over the application of a licence, or the award of a licence, or the non-award of a licence, the judiciary is perfectly positioned to opine upon whether that licence decision was the correct licence decision. That's the role for the judiciary. We see that throughout a planning application. You know, if the applicant is not happy with the decision, where does that ultimately end up? It ends up in front of the judiciary to decide whether the applicant was right or the government was right. And it's exactly the same with this process here. The process that I have put forward in my amendment has the Regulatory Directorate of Government applying a process and making application choices according to government policy, which it is there to, and is the entire purpose of the civil service is there to ensure, apply government policy. And with that government policy, awards or doesn't award a licence. Should there be a dispute, then my amendment clearly states that the licensing assembly is perfectly positioned to decide whether that dispute, and whether the regulatory directorate got it right or whether the regulatory directorate got it wrong. And so actually the amendment I proposed really does put everyone in their right lane. And so I will ask, is it normal for the judiciary to award licences? And that's really where we are today. I will speak, of course, to Deputy Balash's amendment itself. And of course, I understand that he has tried to retain the majority of the draft law that I proposed, and he's trying to preserve the role of the licensing assembly. But I don't believe it's desirable, and I ask members to look at my comments paper and to see further as to why. First and foremost, this amendment, Deputy Balash's amendment, would return us to the current position, as I've said, where licensing decisions are made by the bailiff and jurats. Is that a normal thing for bailiff and jurats to be doing? This obviously takes time, court time, but it has a much more significant impact on appeals. Because the bailiff and jurats otherwise comprise the highest court in the land. And that means that decisions are effectively sent straight to the top. There is no, at the moment, licensing assembly decides an application. If there is an appeal on that, it goes straight to the Royal Court. That in itself is difficult and extremely costly. Parish or emergency services who disagree with decisions of the licensing assembly have only one recourse, and that is namely to go to the Royal Court. Of course, the Royal Court is comprised of the bailiff and jurats. Members of the industry have described this to me as the courts marking their own homework, and explained that this is a huge perceived barrier to applicants being able to find a trusted, independent appeal process. It should also be clear that an apparent absence of appeals is not evidence of a process performing well. We heard Deputy Balash talk about why the system ain't broke, don't fix it. I think that's the perspective from those who sit perhaps on the licensing assembly. It's not perhaps the perspective of those who apply to that assembly. It could just as easily reflect the fact that there have been very few, if any, appeals, could just as easily reflect the fact that applicants wish to avoid what Albert Einstein called the definition of insanity, which is to repeat the same process over and over again, but expect different results. And of course, that is the situation we have at the moment. When you go from the licensing assembly to the Royal Court, you're expecting a different result from the same system. If people don't believe that they are going to get a fair hearing, or that the court is unlikely to change its mind, why would they incur the significant costs associated with taking a case to a judicial review in the Royal Court? Under my amendment, the independence of the court will be preserved so that it can act as a trusted and independent arbiter of appeals and judge whether the Regulation Directorate and parish assemblies have come to the right decision. Sir, there is another issue that I have with Deputy Balash's amendment, and again, this speaks to democracy and the roles of the judiciary and the democratic process. We have seen time and again the licensing assembly award itself new powers, powers which have never been agreed by this state's assembly, and I think this is something that states members should really focus on and think about. So these new powers that the licensing assembly awards itself, or has awarded itself, are based on the licensing assembly's judgment that it possesses an inherent jurisdiction. That's quotes from their own judgment. As an example of this, ma'am, I should say, a 2013 case brought before the licensing assembly found against the licensee, and the then Solicitor General invited the licensing assembly to make an award of costs. When the defence advocate pointed out that the licensing assembly was not a court of law, and that in the absence of legislation passed by the states, the assembly did not have the right to claim costs, the licensing assembly responded with this, and I quote, "For the avoidance of doubt, we reject the advocate's submission. The assembly of the bailiff, governor and jurats, which is the assembly conferred licensing powers under the law, is an assembly which is centuries old. At one stage, it clearly had executive and legislative powers. We are entirely satisfied that this Assembly has an inherent jurisdiction to make an award of costs. So the Assembly there was basically saying, because we once were the executive, we can do whatever we wish with regard to our powers. And indeed, 2 years later, 2015, the Licensing Assembly went further and decided that it exercises an inherent jurisdiction to regulate its own procedure, which in this case allowed it to levy a civil financial penalty, despite there being no such ability set out in the 1974 law. Ma'am, I don't wish to in any way suggest that the Licensing Assembly was the wrong decision, made the wrong decision in those judgments, and it may well be that thanks to its inherent jurisdiction, the Licensing Assembly was able to circumvent an omission with the 1974 law. But it cannot be escaped that the Licensing Assembly fashioned for itself powers which are not set out in the current law and established precedent where previously there was none. That is not a transparent process, ma'am. That is a faceless process that makes up its own rules as it goes along. This is not the way that regulation should work. We in this Assembly are elected by islanders to debate, scrutinise and approve laws. We are meant to set the guardrails within which industries are regulated and say what powers can and can't be used in our name. There is no other regulator, be it the Competition Authority, the JFSC, the Gambling Commission, the Regulation Directorate itself, who has the authority to change the powers that they possess. And that's for good reason, because that is not good governance. These are people's livelihoods that are being regulated, people's jobs and their investments. When operating in this sector, businesses should be able to trust in the rules and to trust that if there's a disagreement between them and the regulator, then they can appeal to an independent higher authority and get a fair hearing. That is exactly what my amendment does. That is not possible under Deputy Balash's amendment. Sir, contrary to Deputy Balash's belief that there is clear accountability in his amendment, the Licensing Assembly is not a transparent body, and that has been proven. There is clear accountability in the process that my amendment speaks of, because every decision made has to give written reasons, and those reasons have to be presented publicly, and they will be presented publicly, and they will provide grounds. If the applicant sees that there are grounds for appeal, they will provide grounds for those appeals. And so, ma'am, I do hope that states members choose the democratic route and ensure that the judiciary does its job well, which will be to hear appeals of the Regulatory Directorate's decisions. And that is absolutely the perfect place for the Licensing Assembly to be, hearing those appeals. And I ask that members support my amendment, and therefore do not support Deputy Balash's amendment. Thank you.
Thank you, Deputy. Deputy Luce.
Thank you, Ma'am. I hadn't intended to speak, but there have been comments made about officers in the Regulation Directorate, which are not ones that I'm familiar with. Comments like faceless bureaucrats do no credit to the people that say that. I'd just point this out to members that 4 officers within the Regulation Directorate have legal degrees, and 7 officers have qualifications within environmental health degrees. And in the UK, having an environmental health degree is necessary to determine alcohol licensing. In the UK, licensing officers within local councils issue licenses, alcohol licenses routinely, and also that's the case in other jurisdictions such as New Zealand, for example. It is a normal civil service function for officers with qualifications in environmental health. Most councils will also, as the Minister's pointed out, have a political licensing committee which would hear appeals against those civil servants' decisions, similar to a planning committee would do with planning decisions. And of course, as the Minister's also said, there's the ultimate appeal to the Royal Court. I just offer those thoughts, Madam.
Thank you, Deputy. Deputy Scott.
Thank you, ma'am. I just wanted to add to the Minister's comments, and indeed the bring of this proposition's comments about separation of powers, but more than that, this advocacy of the licensing assembly being appropriate because of transparency and principles of justice. But nevertheless, it's not actually an executive function. It is a judicial function. And what is being proposed, and I think what's being missed here is an element of which transparency does not necessarily produce justice alone. It's something that I've had to explore in the context of the States of Jersey Complaints Panel. Transparency itself isn't really what's relevant. You've got things like investigatory powers. What is the standard of investigation when it comes to granting licenses? What are the actual rules? And it would be quite appropriate to be following policy. So when we actually discuss things like, as the Constable St Helier mentioned, the need, the relevance in terms of alcohol licensing, in terms of public order, one might well be saying, why might not the somebody set up by the Minister of Justice and Home Affairs be relevant then? But I do believe that the report accompanying the proposition does explain why the Regulation Directorate is appropriate here. And indeed, it's appropriate because it already has a role in administering alcohol licensing. And it's appropriate because it can follow policy rules, which indeed is being covered by this alcohol policy group, which does include people like the Chief of Police, who do have a public order role. So it all makes sense to me. So on that basis, and I agree, talking about faceless bureaucrats, you know, that's not the point. The point is, are they actually following clear rules that people understand, that are consistent, and indeed for which there can be an element of democratic accountability? The last thing I think I actually will say in the actual context of how you administer justice is that nevertheless, and again I think this is a positive, the licensing assembly is there for when people have concerns that rules haven't been followed. At that point, there can be a transparent review. So I understand why this has got the support of people in the hospitality industry, and I certainly will be voting against the Deputy's amendment for these reasons.
Deputy Tadier.
Thank you, Ma'am. So I rise to address one point that was raised by Deputy Balash in his proposal when his opening speech, that saying that the court holds its hearings in public, so the licensing bench, licensing assembly takes place, its deliberations take place in public, and the regulatory directorate will not be making their considerations in public. But I think what we do need to remember in all of this is that there is still an opportunity which the Minister has been at pains to maintain in this new law, which wasn't necessarily his initial thought, which is the requirement for parish assemblies to be held in each parish for new applications and changes to licensing. And I think that actually is the point at which the discussions and certainly the consultation with parishioners does take place. So this is still a very old tradition. It's also a democratic safeguard, I think, and one which arguably, you know, the Minister could have removed. He could have seen this as red tape. He could have thought actually a lot of these licensing applications are just routine. They should be paper-based. So I think there is that opportunity for part of the process, which, as I've said, it isn't reflected in other areas of business, still have that, and that will be represented to the Regulatory Directorate. And we did, of course, consult widely on this, and when we spoke to the Regulatory Directorate, I think we were quite impressed by their capacity to be able to carry out this work. And we were also reassured that there is both an open consultation process, so above the parish assembly, members of the public can also write in. I would expect that those comments would be public, and certainly if people are submitting them, wish them to be, and that also the the Regulatory Directorate have assured us that they will be publishing their judgments as well, so to speak. If we can call them judgments, they won't be called that, but their decisions will be published so that there is a transparency to know why a decision was upheld or why it wasn't. And similarly, I think they said they would publish if their decisions went against the findings of a parish assembly. So the reason I'm rising to stand is to say that actually on balance, and I did take on board Deputy Balash's comments earlier, that he was surprised we hadn't issued comments on his amendment or the other amendments. I'd simply say two things on that. I think the first thing is that we didn't feel that we were in a position really to scrutinise backbench amendments. Our prime role, I think, especially given the current workload, is to scrutinise proposals coming forward by the Minister. But I think that actually our comments in an axiomatic way did actually address what we thought about Deputy Balash's amendment, because we're supporting ultimately what the Minister is putting forward with a small minor amendment of our own, and having balanced the evidence, we think that the Minister's proposal is much preferable to effectively keeping it the same. So I think that should be taken as read by reading between the lines, that we don't support what's being proposed by Deputy Balash. We do think it was worth, though, having the debate on it so that the points could be put on record, sir. I would simply also add to an exchange that we had with the Jersey Hospitality Association, which is in our report. So we asked the question about whether it was a good use of the Royal Court's time to sit effectively as a licensing authority. Sorry, I'm reading the wrong thing there. That's not what was said at all. I'm reading the wrong one. This is up here. I may have to paraphrase. Yeah, here it is. So essentially, can what you want be achieved through Deputy Balash's amendment, leaving it with the licensing bench? Was the question I asked the chair. He said, I think we touched on it earlier, the jurats and the bailiff, simply our understanding from them is that they do not have the time to be administering an application process about alcohol licences. That's probably a point of dispute. I think they may well have the time. I think the real underlying point that he goes on to say here is that they could be sat there doing other things if they weren't there. He said, I think the industry's opinion is that the highest court in the land, that's his comment, should not be the first, in the first instance, a regulator. It should be there, so the jurat should be there where you go for an appeal at the last stage, and where you go if you violate alcohol licensing law. It's not where you begin, it is where you should end. And there's a huge concern that if it starts there, there is no appeal process. So again, we heard the evidence to suggest that the reason there's a lack of appeals, and I don't know if there have ever been any meaningful appeals that have been processed through, we were told that actually there's no point in appealing. Again, the quote is, you can appeal them, but you're appealing to the same people. So there's certainly this perception in the industry. It's not that they're saying that the licensing bench does a bad job currently. They're saying that actually this doesn't look like a modern system, that actually the licensing bench can still exist, but it should be the appeals body, not the starting process, and that they're also mindful that they and their colleagues may have to appear before the court if they are in violation of any alcohol licensing, and that results in any criminal investigation. So I think what we're saying here is that, yeah, it may be difficult, I think, for some to move away from that sense of tradition, but what the Minister's proposing is ultimately better. And this amendment here, I know that the deputies had to propose it in this way. Normally, one doesn't a proposition or an amendment is not in order if it negates another proposition. But I think the way that this has been drafted, this was clearly necessary for Deputy Balash to bring it in this way. But effectively what we've got here is a binary choice. Do we go with what the Minister's proposing, or do we keep what we have now and go with what Deputy Balash is proposing? And certainly the findings of our panel was that we won't be supporting what Deputy Balash is proposing.
Conatable St Mary.
Thank you, Ma'am. And as Deputy Balash said in his opening address, he submitted his amendment before the Minister submitted his fourth amendment. And I have to say, at the time, I had a great deal of sympathy with Deputy Balash's amendment. As I mentioned before in this Assembly, I had the doubtful privilege of being on the Economic Scrutiny Panel back in 2018, where the Minister of the day made certain proposals, and it does sadden me actually to find out that had the scrutiny panel's suggestions then been taken on board, and had the Council ministers not withdrawn their own proposition, so our amendments could not therefore be considered, we would largely have much of what Deputy Balash wants already in place. During the course of our scrutiny investigation research, we had before us the bailiff of the day and jurors. I don't think I'm reaching any confidences by saying that they were happy with the present situation. They were happy to sit more regularly if required. And the main concern they had, or their defence to the main objection they had, was that they had no guidance to determine what was in the public interest, that they had sought guidance, that they wished to have guidance, and the scrutiny's representations very much sought to put in place the policy framework and guidance to be addressed by the Assembly. And if that had been put in place, we would have, I suggest, crossed the moat whereby executive decisions were actually in the Assembly, because the licensing bench today, although made up of judiciary, would have had to have regard to that guidance. And I say, it seems to me we have lost 10 years by delaying that process. So at that juncture, sir, I very much was in support of Deputy Balash's amendment. Moving on, the Minister's lodged his fourth amendment, replacing the suggestion that we have the Gambling Commission in place, and that is certainly more attractive. In many ways, the two are not that far apart, that they both will end up with having policy framework, guidance determined by the Assembly, and to a certain extent, yeah, either is a great improvement. I was co-opted onto the scrutiny panel later today on this, and I don't counter anything that Deputy Taddy has said. I think, to my way of thinking, the two aspects which made the regulatory board a more favourable option were these. One, that in the fullness of time they can bring together more administrative decisions, and it will be easier for administratively to carry those out. Secondly, and it's an aspect which I'd like Deputy Balash to address in his summing up, the right of appeal. During the course of our hearings, the Constable St Helier told us that in his 25 years as Constable, he could not recall an appeal ever having been made. The question is, was no appeal made because the applicant felt there was no purpose in appealing it, or were they satisfied with the actual judgment? And the question I really have for Deputy Balash is, could he please advise, if there was an appeal, how can we be satisfied that that will be a different body and a different set of minds judging the facts as put before them? So on balance, sir, I stay with the scrutiny panel's recommendation that the regulatory route is a better option. If the Gambling Commission one had been the only one, I would have very much been in favour of Deputy Balash's amendment. So I wait to hear what Deputy Balish has to say. Thank you.
Conotab of St John.
Thank you, Mark. I will not be supporting the amendment put forward by Deputy Balash, and I'd urge members to back the Minister's amendment instead. We saw during the debate on the principles that members agreed that we needed to replace the current licensing law by a margin of 40 to 1. However, as we've just heard from my colleague from St Mary's, many members, myself included, did have concerns about the choice of the Gambling Commission. I'd therefore like to thank the Minister for bringing forward his amendment, which has clearly taken on board the feedback we gave during the debate on the principles and which offers a very simple solution, which is to use the Regulation Directorate to determine applications. As the Minister has already said, this is the same Directorate who already administer the law today. They already have the licensing information on all existing licence holders and already manage the application process. The regulation team are also the team behind so many of the other laws which businesses need to comply with, like food safety, hygiene and consumer protection. There's a real opportunity here, Ma'am, to cut red tape across the board and to merge the applications for these pieces of legislation and to merge any associated fees so that businesses apply once, pay once and have a single point of contact when they're setting up. Both the Minister of the Environment and the Chief Officer of the Directorate has assured ministers that no additional resource is required, and there is actually the potential to achieve efficiencies within her department. We've just heard about appeals from the Constable of St Mary, and reading the Minister's comments to Deputy Balash's amendment, I can clearly see why keeping the bailiff and the Jurats out of the initial application process is so important. I think it's wrong that we currently have a situation whereby a licensee's only route of appeal is to go back to the very same body of people who made that judgment in the first place and to effectively ask the court to mark its own homework. This isn't how we deal with any other part of life, and the Minister gave the example of planning. When decisions are challenged, they are heard by a different body and not the same body that made the initial decision. This is really important for fairness and for consistency so that islanders are able to trust in the process and know that they'll get a fair hearing. The Minister's amendment clearly ensures this by separating the decision-making process from the appeals process and establishes the Royal Court's role as the appeals body, which is exactly what it should be. I'm also conscious, Ma'am, that this new law involves more flexibility for parishes and the licensees to tailor licence to the specific context in which they operate. This is a good thing, but it will mean more involvement and that early application phase to design the licence conditions. I don't think we can impose this on the Royal Court to ask them to sit down with every licensee and work up agreed licence that meets the needs of their neighbours and the business. This role is much better performed by parishes themselves and by the Regulation Directorate. Ma'am, I'd also like to speak about accountability of this Assembly. Something that I know the Minister has been keen to ensure throughout this process is that alcohol policy should, in future, be designed and approved by States members and not by the Court. I completely agree with this, and I also think it's important that the powers used to enforce alcohol licensing are carefully scrutinised and overseen by this Assembly as the people's democratic representatives. When we debated the principles of this law, I heard Deputy Alex Curtis voice his concerns over the inclusion of civil financial penalties within the draft law. I agree with the points Deputy Curtis made, and so I'm pleased to see the Minister has taken them out via this amendment. But I'm very concerned to hear that the Licensing Assembly has already used this power to issue fines in the past, despite there being no reference in the current law allowing it to do so. The Minister's comments paper to Deputy Balash's amendment has pointed to previous cases where the Licensing Assembly has decided that it has what it calls an inherent jurisdiction to govern its own procedures. This may have well been convenient at the time, and perhaps the cases heard by the licensing bench were so serious that they merited fines, but it's a very bad precedent to set, and it's not one that I think is compatible with a modern law. My colleague, the Constable of St Helier, spoke about the public's ability to attend court. As Deputy Tadia rightfully said, the proposed changes will still allow the public to attend parish assemblies and comment if they wish. I'm surprised by the Conataba St Helier change of view. His parish have spent what I believe to be a considerable amount of money on external consultants with a view to changing the very process that he now seeks to protect. Ma'am, in closing, I would ask members to consider how they would react if we were approaching the choice between Deputy Balosh's amendment and the Minister's amendment from first principles. If we were starting afresh and offered two choices for how to regulate alcohol, would we choose A, on the one hand, to involve our judiciary in every aspect of the process, taking up valuable court time, allowing them to extend their powers without asking the State Assembly's permission to do so, and in the process denying applicants the opportunity for a fair appeals process? Or B, would we use a regulatory directorate that we already trust to regulate most other aspects of a business, that already works with all licences and the parishes, and that can take on this work without any extra cost? Particularly if doing so meant we could create a fair appeals process, ensure democratic oversight, and take the opportunity to cut out some more red tape by merging processes. Ma'am, I know which option I'd choose, and I'll therefore be voting against Deputy Balosh's amendment and supporting the Minister. Thank you, Ma'am.
Does any other member wish to speak? Deputy Howell.
Thank you, Ma'am. I appreciate very much the Minister for updating the alcohol law and for listening to our views at the last Assembly about the Gambling Commission. But he and I both attended a licensing assembly in St Lawrence recently. It went on for quite some time. It was quite contentious and the vote was close. Parishioners there were pleased that they could attend the licensing bench in the Royal Court and have a further say. They didn't feel that perhaps they had been listened to, but they still wanted to say more. And we have a very good system, I believe, as the licensing bench at the moment. I spoke to a jurat yesterday. They are happy to carry on. I think it's a good process, and I would like it to continue, perhaps with two jurats rather than 5, and perhaps with just a meeting monthly rather than quarterly, so that's fair. It's a good system. It isn't broken. Jersey is Jersey. Let's embrace that. Let's be different. Let's not go down these regulation directorate routes. So I'm going to be supporting Deputy Balash's amendment. Thank you.
Thank you, Deputy. Conataba St Brelard.
Thank you, Ma'am. I stand to speak in support of Deputy Balash's proposal to retain administration of licensing with the licensing bench as at present and not moving it to the regulation department. I have, Ma'am, had many years of experience of licence applications, parish assemblies, to discuss them, and attendance at the licensing bench where I've contributed towards the discussion. I'm supportive of proposals to reduce the number of categories in the licensing law, as it is clear there is much crossing over with the existing regime as dictated by modern requirements. I'm also cognizant, Ma'am, that the hospitality industry would prefer there to be no regulation whatsoever. But whilst we have an obligation to support all industries in the island, we also have an obligation to protect the general public from the effects of excess alcohol consumption by others. And, Ma'am, we have to deal with the outcome of that with our policing role in the parishes. I do look forward to seeing an alcohol policy coming forward, and I would rather have hoped that this policy would have appeared before us prior to this debate. A balance has to be struck with regard to the reduction of licensed categories, so I can, as I said before, support that element. The role of managing taverners goes back for us constables to the 1771 code, so I can assure members that we have an idea what we're talking about, but notwithstanding that, we do need to evolve, and I wouldn't argue that point. I'm more confident in the retention of the licensing bench for several reasons.
I do believe that it's important to have a check on parish assemblies, as whilst democratic in theory, they can be unduly influenced disproportionately by an applicant. And I do recall a situation before my time in office, probably some 30 years ago, whereby a parish assembly vote was significantly swung by the promise of a drink in a nearby bar in exchange for a vote. I was made aware that that bar in question took an additional £700 that night over their normal take. So on that occasion, I have to say the application was for a provisional licence. It was passed and has proved to be a successful business ever since. Another reason, ma'am, for the retention of the licensing bench is that it adds gravitas to what is an important role in our society. The operation of licensed premises should not be allowed to get belittled. An examination of applications not only enables those members of the public who've spoken at the parish assembly at the risk of emphasising what others have said, it also allows them to emphasise their views, but also receive further consideration by the licensing bench, who are used, as has been referred to by others, used to making balanced judgments as necessary. The Minister's proposals shift the existing process from the licensing bench to the regulation department, and whilst I have the greatest respect for those working in that area, I don't believe a civil servant in Union Street will command the same respect as that of the licensing bench. Should we be following a UK example which has the whiff of making the process glutinous, which is certainly not the case at present, where we have a very flexible licensing bench, but we do have experience of planning appeals, which quite often are. There will be no opportunity, ma'am, for members of the public to meet this authority, and I believe that will be regrettable. Face-to-face dialogue is so important and mustn't be overlooked. Yes, people can email, yes, they can write, but people do like to explain their view in person. As has been mentioned before, I'm not aware of an appeal against the licence bench decision, so I don't believe the Minister's proposals which state a reason for the removal of the bench from the process are justified. My experience is, ma'am, that the bench actually deal with any issues before it gets to the point of the assembly, and that has to be the right way to proceed. There is the question, ma'am, which we haven't explored, of licensed premises managers, and this just hasn't been considered in the latest proposals. Applicants are presently interviewed by the constable, who effectively checks their credentials, and they are sworn into the role by the Sandy Division of the Royal Court. Now, my understanding is that process will remain. I think it's an area that probably should be reviewed in the whole process of looking at this law. I do feel the proposals are being rushed in an unseemly way pre-election, and would prefer to retain a degree of the status quo before proceeding with the proposed administrative changes, which may have subsequent consequences which we haven't considered. So for those reasons and the fact that there are too many loose ends, I can't support the Minister's proposals, and will be voting for those put forward by Deputy Balash, as they satisfy the hospitality needs in the short term and leave the administrative structure in place without destabilising the process of issuing alcohol licences. Thank you, ma'am.
Thank you, Conatap. Does any other member wish to speak? If no other member wishes to speak, I close the debate and I call upon Deputy Balash to reply.
Thank you, ma'am, and I thank all members who have participated in this debate. The Minister opened by asking why should it be a judicial process. Rather naughtily, I thought, wondered if the judiciary was still ruling Jersey, but the Assembly of Governor, Bailiff and Jurats has not ruled Jersey for at least 500 years. Indeed, not since this assembly came into existence. The reason why it is or should be a judicial process is that intoxicating liquor has always caused problems in society. Many of those in HM prison are there because of excessive consumption of alcohol. And so it is important to hold the scales between the legitimate enjoyment of alcohol in pubs and restaurants on the one hand, and the abuse of alcohol on the other. And holding those scales is a judicial function in many places. It's certainly, I'm afraid I'm not sufficiently up to date, but it certainly was the case in England, where justices of the peace exercised licensing functions, JPs being the equivalent of jurates. The Minister's comments paper, to which a number of members have referred, makes several surprising observations, some of which were echoed by the Constable of St. John. First, it suggests that judicial review of the Licensing Assembly's decisions is the court marking its own homework. And that comment seems to me spectacularly to misunderstand the nature of the judicial process. Judges are independent. They constantly sit in judgment over the actions of other judges. What happens when a criminal appeal goes from the inferior number of the Royal Court to the superior number? You have a judge and a larger number of jurates deciding whether the lower court has gone wrong. That's not marking your own homework. It's an independent review of the first decision. Secondly, the Minister states that the Directorate would still be required to administer the law. Well, indeed, that's what happens now. The Assembly would make the decisions, but the preparatory work would be done by the Directorate, as now. The paper states, and I quote, "The alternative would be to incur very significant costs in setting up an entirely new process." I simply don't understand that statement, which seems to me to be quite wrong. My amendment sets up no new process. It is the Minister's amendment which sets up the new process. And finally, the Minister suggests that the Assembly, in occasionally imposing a fine, is somehow usurping the functions of the State's Assembly, a notion that was again echoed by the Constable of St. John. The Licensing Assembly is indeed a customary law entity which is entitled to fix its own procedure. It does not often impose fines, but sometimes it is appropriate. In 2017, Jersey Bowl was referred to the Assembly by the Attorney General for disregarding provisions of the law by selling alcohol after hours, permitting the public to be on the premises after hours, and allowing drunkenness on licensed premises. The Assembly could have suspended or revoked the license, but it did not wish to do so because Jersey Bowl was, generally speaking, a well-run business, and more importantly, the public would have suffered if the business had had to close. So a fine of £25,000 was imposed. And what was wrong with that? If the states wish to limit the powers of the Licensing Assembly by, for example, setting a maximum fine, the states can do that. Under my amendment, indeed, the states would subject the Assembly to control by imposing policy guidance. The Assembly exercised a lawful power in imposing a fine and certainly did not usurp the functions of the states. The Minister concludes by suggesting that he wants, and I quote, to ensure that alcohol licensing remains subject to a wholly democratic process. I'm not sure that I would describe vesting total power in a single civil servant, wholly democratic. But the issue is indeed whether we want to substitute an administrative process for a transparent quasi-judicial process with a very long history. I'm not going to go on, sir. I don't think that the Assembly should throw out the baby with the bathwater because it is not in the public interest. I ask for the appel.
Thank you, Deputy. When you ask for the appel, are you wanting the appel for your entire amendment, or do you wish to take it in parts as suggested in the running order?
I'd like to have the amendment voted on as a whole, please, ma'am.
Thank you. Thank you. Very well. The appel has been called for. I ask members in the vicinity to return to their seats. And I ask the greffier to open the voting. All members have had an opportunity to cast their vote. I'll ask the greffier to close the voting. And I can announce that the amendment has been rejected. There were 11 votes pour, 35 votes contre, and 1 abstention. Greffier.
Those members voting for the Connétable St Helier, St Lawrence, St Bellard, Trinity, Greville, St Juan and St Saviour, and deputies Banash, Rose Binet, Howell and Barbara Ward, and the Connétable St Clement abstained.
Thank you. We now move to the fourth amendment lodged by the Minister for Sustainable Economic Development. Again, it's a long amendment. Are members content to take it as read?
Yes, ma'am.
Thank you. Then, Minister.
I did actually think we were going to the panel's amendment first.
Well, you have to put forward your amendment, and then the amendment to that
Then
amendment
the
comes
amendment
next.
to that amendment. Apologies, it's always confusing. Thank you, ma'am. Following our debate on the principles on the 22nd of January, I carefully reflected on the points which members made and have brought forward this amendment in recognition of the concerns which members had over the use of the Gambling Commission. Members were clear that they were supportive of the principles of the draft law and that they agreed with much of what we were trying to accomplish. But there were clear reservations about using the Gambling Commission. So I accepted this feedback, and this amendment removes that commission from the process entirely. In finding an alternative, I have been keen to ensure that we do not lose sight of the objectives which led to the choice of the commission in the first place. This means ensuring that we find an alternative that delivers consistent and experienced decision-making, which allows for a clear and trusted appeals process, which does not increase costs or require any additional resources to take on the role. Ma'am, I believe the Regulation Directorate delivers on all these objectives and provides a unique opportunity to go further. Firstly, the Directorate already administers the existing licensing law and has done since 2020. Over the last 6 years, they have streamlined the application process, developed their collaboration with the parishes, the States of Jersey Police and the Fire Service, and built a modern database with information on all existing licensed premises. They have very clear procedures for decision-making and inspections and have the trained personnel already in place to expand their existing work for alcohol licensing. The head of the Regulation Directorate has also confirmed during a recent scrutiny hearing with the Economic and International Affairs panel that the Directorate already has resources and expertise to deliver this work and to do it very well. This means that it is ready to step in to take over decision-making with minimal disruption. Ma'am, I apologise for repeating some of the things I said in my previous speech on the previous amendment. But by using the Regulatory Directorate, we can preserve the independent role of the bailiff and jurats, enabling them to act as a trusted appeals body, which isn't involved in that initial decision-making. This also means that additional attention can be given to each individual application, with businesses working with officers within the Regulation Directorate to evaluate their applications and conditions in real time, rather than waiting for the next meeting of the licensing bench. I think it's very important that members do listen to the Environment Ministers perspective on the qualifications of the Regulatory Directorate and the work that they are doing. It's also worth saying that officers in the Directorate come with qualifications from the Institute of Licensing, which is the body governing best practice in all types of licensing, including alcohol and events. So they are an eminently qualified body. It also means that additional attention can be given to each individual application, with businesses working with officers within the Directorate, evaluating those applications and conditions in real time, rather than waiting for the next meeting of the bench. Members will be aware that the Regulation Directorate already manages 36 pieces of legislation, many of which overlap with alcohol licensing, including food safety, hygiene and consumer protection. During its review, the scrutiny panel heard that from the Group Director for Regulation, who confirmed that, as I've already said, that her team has the capacity and the capability to undertake this work. It is here that the Regulation Directorate offers an opportunity to go further and improve upon the previous model, which would have used the Gambling Commission. Because the Regulation Directorate already manages these pieces of legislation, which impact upon the business of selling alcohol, we can, as other members have said, reduce red tape and cut down on paperwork by merging the application process and other behind-the-scenes procedures. This will mean less cost for government, less paperwork for businesses, fewer inspections, because the inspections for the food licensing can be undertaken at the same time as the alcohol licensing, so it will be fewer inspections. Sir, or ma'am, during the debate on the principles, there was overwhelming support for change, but members understandably had questions about the use of the Gambling Commission. I believe that the current amendment finds the right balance by securing the changes we all want to see without handing powers to a new entity. Furthermore, by using the existing administrators of the current law, we can reduce costs and combine paperwork across a number of laws to remove red tape, and we can preserve the independence of our judiciary so that they can continue to act as an impartial appeals body. I think it's incredibly important that we will be creating a system which manages to speak to our heritage, as members have said today, but at the same time move forward into the future and a more modern system. And that is something which I believe Jersey is strongest in, using our history to determine our future. And this amendment, as I propose it, does exactly that, ma'am. I would also quickly like to thank both Deputy Curtis and the Economic and International Affairs panel for their amendments, which, as I said, I'm very happy to accept. And I think they further enhance the proposed law as well, ma'am. And so with that, I propose my amendment.
Is the amendment seconded? There is an amendment brought by the Economic and International Affairs Scrutiny Panel, and I ask the greffier to read that amendment.
Page 2, Amendment 3. In Amendment 3, in inserted Article 3.2, delete subparagraph F.
Chair.
Thank you, sir. I'll give some context to this amendment by setting some of the background to it. So I think what the Minister's proposing here does a number of things which I think are important. I think one of the things we're all agreed on is that the reduction in numbers of licensed categories is a good thing. I don't think anyone's got a problem with that. I don't think any member's going to be not supporting that. I think one of the other key things that it does here, which is perhaps not necessarily being fully realised, but I think is vitally important, is that it removes the ability for policy making when it comes to alcohol effectively from the judiciary and the court and the Attorney General, who at the moment, as we know, has been responsible for implementing alcohol policy to, I think, where it should be, to politicians. And that's no criticism, by the way, of any of the functions that are currently being carried out or suggesting that they're not being done properly. But it is a recognition that ultimately policy matters and politics should be done by politicians, and it's right that politicians are accountable for those decisions. The Minister, I don't think, will mind me saying that during one of our hearings, it was commented that there had been an increase in the minimum unit price of alcohol, and that some members of the public had noticed that. And they got on the phone. I think they'd been in contact with the Minister and possibly with some other members, or if they hadn't been contacting him directly, there was certainly some commentary on social media, and it was to the effect of, oh, those good-for-nothing politicians, they've only gone and put the price of alcohol up again. at a time of cost of living crisis. And of course, we slightly jokingly said, so Minister, you're probably getting that in the neck at the moment, aren't you? And you know, but it's not you who's made the decision, is it? I did jokingly say, I hope the Attorney General won't mind. I did ask whether it would affect the Attorney General's chances of re-election, having made that slightly controversial decision, sir. And that shows me, and I'm not the only one, that actually I've been very uncomfortable with the inability of this Assembly to make quite right decisions, and sometimes measured and balanced and complex decisions when it comes to the area of what our alcohol policy should be. Because it needs to take into consideration things like health. It needs to take into consideration the economy, also, you know, one's freedom of choice and ability to enjoy oneself, and the respect for communities and neighbours, etc. So all of these things need to be taken into account in the formulation of policy. And I do think back to a proposition that was lodged very much in this vein in 2020 by, I would like to call him my good friend, Deputy Ash, and make sure I get his name right, and we had some great fun, I think, both in and outside of this Assembly, and although in the Venn diagram of perhaps left and right or libertarian and whatever, there was certainly a crossover point, sir, in the middle where we both recognised that there was an issue here. So he lodged his proposition in 2020 called P105, which was to do with the title of which was Drinks Promotions quite shortly. And he did recognise that there was an absurdity, of course, that, for example, shops could have special offers. So they could do a buy one, get one free. They could do buy three for £5 when actually a can might cost £3.50. But pubs themselves couldn't do it. And he asked the rhetorical question, so is it because we want people drinking in their homes, not in the controlled environment of pubs and bars? Now, these are all great questions that need to be asked, and they need to be ultimately asked by elected politicians, and they need to be given consideration by elected politicians, preferably, I would say, by ministers, and that ministers need to formulate their policy, present it to the Assembly, that needs to get endorsed, and then it needs to be voted on, sir. So with that in mind, we looked at the list of how the policy panel would be put together, the alcohol policy group's membership as proposed by the Minister has different categories. So let's look at the first three. So it must include the Minister for SED, who chairs the group. It must also include the Minister for Justice and Home Affairs, and it must include the Minister for Health and Social Services. So for my part, and for the panel's part as well, that makes entire sense. I say these are certainly the three political representatives you would want on that body. Their roles might vary over time, so it might be necessary in the future if, for example, that a future Assembly thinks that we also need to give consideration to the role of education when it comes to alcohol policy. It may well be that a future Assembly wants to include the Education Minister, but it seems entirely logical, given what we've already understood this morning, that there are economic, health and social and health factors included in that those three members in the future should be on the board. I think when it becomes slightly more of a wish list, if you like, is that there's an inclusion of the Constable of St Helier, which is very specific, and that another constable should be nominated, which is any other member from the Comité de Connétable, and then the Attorney General lastly. So we did consider all of these roles and whether they were right and whether they could be justified. And I must admit, I certainly spent a lot of time thinking about whether or not it was appropriate to have two constables on there. The panel considered this. We understood the argument is that because St Helier has most of the licence applications, the Constable of St Helier should be on there automatically. We were also told the argument for putting another constable on there is so that there's balance. There are 11 other parishes that might have different needs to St Helier, and it's important to represent those. I must also say that my starting point was that the group should be comprised solely of ministers. So we did consider whether there was a way to look into that, to say should could there be an amendment which says a constable should only be on that board if he is or she is a minister? I would hope that may be taken into account in the future, but it was very difficult to come up with an amendment to that. And I am getting to the point of the amendment, which is what we're proposing, Mum, is that the Attorney General should not sit automatically on that body, so he shouldn't be a named member of that group. The reason for that is that we believe that it might create a contradiction, really, because what we're doing at the moment, what the Minister is doing in proposing this new law, is removing policy-making powers from the court and from the Attorney General. And in doing that, it would perhaps blur the lines to say that actually putting somebody on that group who's not a politician, who's not elected, and whose mandate is not to make policy in that area, actually does not fulfil those the criteria which we laid out in that. So it's nothing personal, as I've said, and we also recognise that nothing within that would stop the policy board from taking advice from the Attorney General in the same way that ministers can already seek legal advice from him in that regard, sir. So that is the nature of the amendment. I'd be interested, of course, to hear from other members whether they think that there's a good reason that can be made for the maintenance of that list as the Minister originally proposed it. But I do recognise also, and thank the Minister, that he's accepting the panel's amendment. I do reassure members that we have gone through all the options on this, and we've thought about in great detail about who should be on that, who shouldn't be on that. And also we recognise the fact that it can be future-proofed and it will need to be given consideration in the future, sir, Ma'am. So I do maintain the panel's amendment.
Is the amendment to the amendment seconded? Does any member wish to speak? Deputy Morale.
Thank you, Ma'am. Ma'am, I'm happy to support this amendment, which ultimately removes the Attorney General automatically from the alcohol licensing group. I had proposed originally, as the Chair said, that the Attorney General be included as a member of a group given his current role in kind of developing and executing the alcohol policy and licensing process. But that was with a view to that membership being removed at a later date following the transition process. I do, however, agree with the panel that it is important to draw a clear distinction between policy development by politicians and the prosecution of laws by the Law Officers Department. Indeed, that was the perspective that I was saying in my previous speech, and therefore agree that the Attorney General should not be a full member of the group. Of course, anybody can be invited to advise that group and sit on that group, and we will, of course, make sure that the Attorney General and Law Officers Department are consulted when considering matters before the group. And so the group will itself work closely with the Attorney General. And I have spoken with the Attorney General, and I don't believe there are any objections from, although I don't like speaking to somebody else, from the Attorney General's perspective. Ma'am. So I ask members to support the panel's amendment.
Thank you, Deputy. Attorney General, would you like to speak?
Thank you, ma'am. Given that my office is the subject matter of this amendment, I hope it will be appropriate for me to speak to it very briefly. I mean, no criticism of the Minister or his team, but my department was not consulted beforehand as to the makeup of the policy group. Had we been, my view would have been that this is an area of island life in which the attorney's role is more appropriately that of a legal advisor, not a policy maker. I'm with the Licensing Assembly, who I think said something very similar some years ago, that policy in this field should be set by elected representatives. I hope that's helpful.
Thank you, Mr. Attorney. Does any other member wish to speak? If no other member wishes to speak, I close the debate and I call upon Deputy Tadia to reply.
Ma'am, thank you. Can I thank the Minister and also the Attorney General for his intervention? And I don't think I need to say anything else, so I'm just going to sit down. Thank you.
Do you call for the appel, Deputy?
We should probably have the appel, I think.
The appel has been called for. I ask members to return to their seats. And I ask the greffier to open the voting. members have now had an opportunity to cast their vote. I ask the greffier to close the voting. And I can announce that the amendment to the amendment has been adopted. 44 votes for, no votes contre, and 1 abstention. We now return to the Fourth Amendment as amended. Does any other member wish to speak? Deputy Luce.
Thank you, Ma'am. Ma'am, I welcome the Minister's amended proposals to simplify alcohol licence categories. This will provide greater flexibility, reduce complexity in fees, and remove unnecessary red tape. During the earlier debate on the principles of the new law, the Minister highlighted the significant administrative work already carried out by the Regulation Directorate in my department. As he said, this is where applications start and finish today. He also recognised that the Directorate already completes the majority of this work. I'm pleased that the amendment now reflects this reality. It places confidence in the Regulation Directorate to play an enhanced role in administering the new system and in making licensing decisions. This is a sensible, practical approach. It is the work we are already doing. Importantly, this in-house solution does not create new financial or resource pressures. The system will continue to be funded by fees paid by businesses. My department is well placed and ready to take on the extended functions. The Directorate already has strong working relationships with the Licensing Assembly, the parishes, the police and honorary police, the Fire and Rescue Service, the Judicial DREF, and the Law Officers Department. We also hold the expertise to manage licensing decisions, as demonstrated through the range of legislation we already administer, from food safety and hygiene to consumer protection and weights and measures. Officers routinely grant and refuse licences under other laws, including waste management, water resources and public health. In the future, a potential improvement we wish to explore is the possible integration of alcohol and food licensing into a single online platform. This will significantly reduce administrative burdens, particularly for new businesses. The Directorate's existing structure allows for consistent decision-making aligned with the alcohol policy framework and, crucially, faster decisions with availability every working day of the year. Expanding our role also supports a more joined-up approach for businesses. The Regulation Directorate's enforcement policy is based on the 4 E's: engage, explain, encourage, and finally, enforce. This approach gives us a proportionate and flexible approach, allowing officers to focus on the specific issues within businesses and support them in reaching compliance. The decision-making and enforcement will be undertaken by senior qualified officers in the Environmental and Consumer Protection team, whilst the licensing applications, processing and customer service will be led by the Regulatory Improvement and Licensing team. To conclude, Extend the Directorate's remit offers a practical, cost-neutral and efficient in-house solution. We have the trained staff, digital systems and experience to administer the alcohol licensing regime smoothly and to take on the additional responsibilities confidently. This is quite simply our bread and butter work. I would encourage members to support the sensible and pragmatic amendment. Thank you, Bob.
Thank you. Does any other member wish to speak? Conatub of St John.
Thank you, Ma'am, and I'm also happy to support this, but I would ask the Minister to confirm that any renewal of a licence will have to, the person applying for the renewal will have to confirm that they have the landlord's permission to renew their licence, as I'm aware of cases in the past where they haven't had the landlord's permission. Thank you, Ma'am.
Does any other member wish to speak? Deputy Tadier.
Ma'am, I just wanted to acknowledge that the Assembly has been through an iterative process, which it doesn't always do in this way, it was quite clear that there were political issues with what was being proposed in the first instance, and I think it was all being done absolutely for the right reasons with the correct motivation. And I think there was some unfair criticism of the Minister that he hadn't done sufficient consultation. I don't think I see any evidence of that. We didn't see any evidence of that as a panel. But it was clear that there was some kind of impasse when this was moved in the first reading, because the model being proposed by the Minister for various reasons, and we won't go into the details of that, was not acceptable to a significant number in this Assembly. And I think we were absolutely right in pausing it for the second reading. I still stand absolutely by the panel's decision that it would have not been appropriate for us to scrutinise it at that time. And I think what needed to happen, and what did happen, is that some of the heat was taken out of that, and then some more light did ensue in coming weeks. And it did also give the Minister, I think, an opportunity to take stock, to speak to others and other stakeholders. And what he's proposing now, I think, is much better. I think keeping it in-house like this, so to speak, with a regulatory directorate who I think do excellent work. Often, I think they're not a big department, and I think it does represent value for money. And I think when we hear comments more generally about a clamour for small government, I think actually what we're recognising here is that we didn't need to make up a completely new body, which would probably, in some ways, I'm sure they would have been entirely capable, but may have been the worst of both worlds in some ways, that they wouldn't have been under any kind of political oversight, but again, we would be moving away from an existing body which was not dissimilar. And I think what's been achieved here is an example of a good compromise, but a compromise which doesn't actually compromise outcomes, but actually enhances us, brings us forward. And I certainly would like to commend ministers for working, and also the great work that the Regulatory Directorate already does. And I emphasise in saying that none of this diminishes the roles that the parishes already do. We do also recognise that a lot of the administration is initially done by, and will continue to be done by, the parishes, and that the very important democratic function of the parish assembly, I would argue even parish assemblies which are not necessary because the licence is so uncontroversial, but it's still there. And I would make the point that actually somebody who goes to a parish assembly currently and would expect it to have been able to speak at a licensing bench, I mean, I think that is, of course, something that some may miss, but I think the reality for so many islanders is that they don't even have the time to go to a parish assembly. They don't always know when they are. Some parishes have them better than others because they're regular. Other small parishes, of course, don't necessarily need to convene licensing assemblies that often because they're quite a rare thing. And then to also have to be free when the licensing bench sits to go and speak to them again to tell them what you've already said at a parish assembly, I think for many people seems like unnecessary mind-boggling duplication. If you go to a parish assembly and make your voice heard, I would hope that you would rely on your parish constable to take those comments forward. And certainly those comments that you make already will be presented to the Directorate for their consideration. And the addition, I think, of the online portal where comments can be received is a little bit, feels to me a bit like the planning application process. Anybody in the island can now comment on an application for a licence, even if you don't live in that parish. And I think that's really important because there will be places and pubs, restaurants, clubs in Jersey which sit at the crossroads between maybe 2 or 3 parishes. So you might live across the road and find yourself in a strange situation where you're not technically, you're not a member of the assembly. A good constable, I'm sure, would still allow you to attend and speak because you're a stakeholder, but you wouldn't necessarily have an automatic right to speak, and you certainly wouldn't have a vote when it comes to that assembly, even though you live across the road. So I think having this belt and braces approach where you can attend a parish assembly and submit through a portal, even if you live the other side of the island, I think that's all moving us in the right direction, Mark.
Monsieur le Deputy Curtis.
Thank you, Ma'am. And it's really, Deputy Talia touched where I was going. I put my light on a little before to thank the Minister for taking on board the feedback and in particular to highlight the addition here of the ability to make written representations. I think a statutory right of representation in a way that is recorded and published is an important thing to have. I was discussing with other members the benefits and disbenefits of the licensing assembly, and I felt in either situation we would have had a workable law. But one example where we talked about transparency, which I recall from my own experiences, and I pass no criticism or judgment onto the licensing assembly, was I recall years ago requesting the minutes of the licensing assembly to understand how decisions were made, how some of the more nuanced categories were being applied, and I was informed that minutes were not shareable for regular licensing assembly minutes. Extraordinary decisions are accessible on Jersey law and JLIB, as members will know some of the more contentious cases, some mentioned today. But I think the fact that every application will have or every new application will have a reason for determination will hopefully inform those applying for where they may wish to improve and make changes. And I leave with one more comment, which is we seem content now that this can sit with the regulation department, that they are skilled, and it may be for the next assembly to ask whether gambling regulation could also sit with them.
Does any other member wish to speak? If no other member wishes to speak, I close the debate and I call upon the Minister to reply.
Thank you, ma'am, and I'd like to thank all members who have spoken for their comments. With regard specifically to the Connaught Harbour St John, yes, I'm very pleased to be able to confirm that the amendment, if adopted, includes a specific clause which states that a licence is voided if the licensee ceases to have a right to occupy the premises to which the licence relates. And if this that's Article 8 under the renumbered amendment. So yes, that would be avoided and is an important aspect, as we have seen. In the first instance, I'll save the thanks for the third reading if possible. So in that sense, I would like to just put forward my amendment using the Regulatory Directorate. I'm incredibly grateful to the work of the Regulatory Directorate team, the Environment Minister, whose department that sits within. But I do hope that members can see the benefit of this, that I have listened to the States Assembly, and as the chair of the scrutiny panel saying, Deputy Tadje, that is the parliamentary process in action, and that's the right thing, and I'm really proud of that, and I think that's something that we should all be proud of. It shouldn't just be a case of something comes here, it gets accepted or rejected, and that's it. The idea that something comes here and you have an iterative process which brings it into a position which more members can agree with is exactly the way the State Assembly is meant to work. And it's not something we see very often, but I think in this case, I think it's something that I've been pleased to see and pleased to be a part of. With that, I thank members who have spoken, and I will ask for the appel on my amendment.
Very well. The appel has been called for on the Fourth Amendment as amended. Members are invited to return to their seats. And I ask the greffier to open the voting. If all members have had an opportunity to cast their votes, I ask the greffier to close the voting. And I can announce that the amendment as amended, Fourth Amendment as amended, has been adopted. There were 43 votes for, 2 votes contre and 1 abstention. Greffier.
Those members voting contre, the Connaught Harbour St Lawrence and Deputy Balash, and the Connaught Harbour St Clement abstained.
We now come to the amendment lodged by Deputy Alex Curtis of St Clement, and I ask the greffier to read the amendment.
Page 35, Article 22. In Article 22.1, after subparagraph J, insert K. Tap water must be provided without charge to any customer who requests it, unless it cannot easily be supplied.
Deputy Curtis.
Thank you, Ma'am. Not quite the length of amendment from Deputy Balash, so I can keep this brief. The amendment introduces a new general condition into the licensing law that would apply to on-licences. The wording is, as read by the Assistant Greffier, tap water must be provided without charge to any customer who requests it, unless it cannot easily be supplied. Tap water is chosen as it is ordinarily taken to mean water provided from a tap that is intended and safe for drinking, and it does not compel businesses to provide bottled water. The second part of this is a condition that provides qualification. The inclusion of the phrase, unless it cannot easily be supplied, allows that if a premises does not have a plumbed water system that provides drinkable and potable water, then it cannot easily be supplied, and thus they do not have to provide a supply they do not have. It does not compel them to upgrade their water supplies to do so. The reason for the amendment is simple. We all know that for health, it is important to drink water whilst consuming alcohol for a range of purposes. It is one of the easiest ways to ensure public health considerations are factored into drinking in licensed premises. And before I go on, and it's not going on for long, I should say that the vast majority of unlicensed premises supply water free of charge to consumers, so members might question the need for this. There are two. First, it would cover any of the few remaining operators who have capacity, i.e. a drinkable tap supply, but currently don't provide free water to customers. And these do, from my experience, and have at least existed in Jersey. The second, and the reason I consider that primary legislation is the right place for this to live, is it provides customers with an accessible place to know their statutory rights. While many of us may feel comfortable asking for tap water, I do know that not everybody is, and placing this here enshrines that right and comfort for customers to know it is well within their rights to ask that if they are purchasing another product. This is similar to other general conditions and the requirement in the primary legislation for premises to publish prices. It provides consumers a place to go to know those rights. Free access to water in the course of being a customer in a licensed premises is a known issue. The UK added this to their mandatory conditions by order to their Licensing Act. And in 2009, the then review of our law highlighted this as a concern. I would say to members that whilst this is minor, I brought it because no matter how small, I genuinely believe this is an improvement to the law, and it is our role to look at the law and improve it where we see fit. I'm glad the Minister can support, and I ask the rest of the Assembly to do so.
Is the amendment seconded?
Yes, ma'am.
Does any member wish to speak?
I may wish to speak, but I don't want to put my light on, but I'd like to ask for the adjournment.
Sorry, I was getting carried away with the excitement. I hadn't had an eye on the time. I'm in members' hands. It is the time that we would normally ask. Is the adjournment is proposed? Are members willing to accept that? Kindly show. The amendment is adopted. The adjournment is adopted. The Assembly stands adjourned until 2:15.